right, good morning. Is this on? Can you guys hear me? Is it loud enough? Okay, good morning. How are you guys doing? I know Mary's excited. Oh, John, this is going to be fun. I promise you. I've got some videos as normal. We're going to have some fun. We're going to have some little gamey kind of things. We're going to keep your attention. There's snacks on the table. There's snacks in the hallway. We don't want you to go hungry or thirsty. If you don't know, I'm Shauna Billingsley. I'm the city attorney. And my staff are here with me. Bill Squires, he's the assistant city attorney. Blake's in the back. Blake Harper, he's the staff attorney. Amy Sue is at the table. She's our legal assistant. And I do not see Tabitha or Stephanie, but they'll be in and out as needed. Your agenda is in your packet. If you don't have a packet, see Amy Sue and she'll get you one. Also, if you have never picked up a Robert's Rules book, most of you should have one. But if you don't, they're up here at the front desk for you to take and read at your leisure. And I think I'm going to turn it over to Bill. If you have questions, let's just ask him as we go, if you're okay with that, Melissa, because it's just easier to wait than to wait till later. So I'm going to turn it over to Bill to introduce our speaker.
Morning, everybody. How are you? All right. I'm getting some response. That's good. Don't forget water and coffee are around the corner. If you need coffee, please feel free. Restrooms are in the back. Listen, it's, you were here last night. I'm pushing the... So, as Shauna said, if you for some reason don't know me, I'm Bill Squires. I'm the assistant city attorney. I'm introducing our first speaker. We're very excited to have so much input and help from MTAS. If you're not familiar with MTAS, they're an organization through the University of Tennessee created literally to provide assistance and support to cities and towns across the state. We use them from time to time, reach out to them, work with them on different things. They help us with questions we have. We have a couple of folks here from MTAS. Ab is in the back. And then we also have Melissa Ashburn here. She's going to present to you about public records and open meetings. Melissa is extraordinarily qualified. She's been with MTAS at Helping Towns and Cities since 2001. Correct me if I'm wrong, her area is primarily the western part of the state. They kind of divide things up. But she's been doing this for over 20 years. And she does these kinds of presentations across the state over and over and over again to help people kind of get these issues under control or understand them. So everybody give a big round of applause. Let's welcome Melissa Ashburn.
Good morning. First, I want to second what Shauna said. If you have any questions while I'm talking, if I say anything that's confusing, please speak up, because I guarantee you if you're confused, someone else is as well. And first, I want to point out to you just how fortunate you are in Franklin. Thank you so much for serving your community, first of all. We have little towns in Tennessee that can't even get people to run for elected office. And all of you are here today because you're serving your city. Local government is only good because people like you spend your time and effort and energy working with the city and trying to improve the lives of the people in your community. So thank you. I appreciate that. Now, something else you may not be familiar with is the wide variety of municipal government in Tennessee. We have 345 cities. I think our smallest one has less than 200 people in it. I get questions from all of them. I really do, literally. Yesterday I answered a question for a city that had a population of 300. When I made it to Franklin and had 7 voicemails, half of them were from cities about 50,000 size, and everyone needs a question answered. And I gotta say, sometimes when the questions come in about zoning ordinances and planning and parks and rec and different functions and how do we do this, I say, look at what Franklin did. I use you all as an example of good governance. So I hope you appreciate just how fortunate you are in your community to have so many people so invested in your city government. And again, thank you so much for all that you do. Now, how many of you have been in this training before? Okay, I want to start out by apologizing for not being Alicia Hodge. Alicia left MTAS in December, and no one is more heartbroken about that than I am. But we're going to try to muddle through. Thankfully, she's at Public Entity Partners, still doing risk management for cities, so she's not entirely out of your realm. But unfortunately, she could not be here today to do this. Okay, so we will go into executive session before we hit public records, because executive session is this one exception to open meetings that is still very confusing to a lot of cities. One thing you might not be aware of is we have one of the broadest open meetings laws in the entire country. You know, most other states have laws that have a section that recognize the city attorney can call for executive session about any time. We don't even have a section of our law that recognizes executive session. Instead, it's a constitutional court doctrine that we're going to be discussing later. So again, as I go through this, if I say anything that's confusing, just raise your hand. And I'm going to do my best not to contradict anything that Shawn has told you, because trust me, she is the source for information in your city. Our programs tend to be more general because we're talking, again, some cities with 300 population with city councils, and then you have larger cities with board of mayor and aldermen. So the slides you will see are rather general, but I'm going to fill in the gaps and give you more specific information as we work through this. Okay, so this is the language from the law. And it seems pretty simple. There's not a whole lot of wordage in there, not like some of the laws that we see these days that you got to read 4 or 5 times to understand that it's speaking English, actually. So it says, all meetings of any governing body are declared to be public meetings open to the public at all times, except as provided by the Constitution. So there's 2 parts to the analysis, and that is, 1, is it a governing body? And 2, is it a meeting? So meeting and governing body, those are the 2 issues you got to suss out under the open meetings law. Seems pretty easy, doesn't it? Well, it's really not. So this is the interesting part. I don't know if they could have made this more confusing. The members of any public body, which consist of 2 or more members, with the authority to make decisions for or recommendations to a public body on policy or administration. This means every single board created, every commission, every committee created in your city by your governing body, that is a public body. And if there's a commission or a group that ties into state legislation for creation, they're subject to open meetings as well. So your Civil War Historical Commission, your Planning Commission, your Board of Zoning Appeals, you all also have a budget committee, and I'm trying to remember the various committees I saw on your website last night. All of you have to have open meetings. And there's going to be very, very few circumstances under which you would not have an open meeting. So it's best just to get in the mindset that, hey, it's got to be open, it's going to be open all the time, because that's what we're faced with here in Tennessee. So we also have some language in the law that makes it really clear the legislature intended all courts to interpret the law very broadly, so to provide the most access to public meetings possible for our citizenry. So what that means is, if you get into a dispute about open meetings, you're already on the losing side because you're the government. It's always best to try to work it out and solve the problems before you reach litigation. Let another city go down that road and then learn from them. That's what we do. So we've talked about, the different entities created by your city are a governing body. But this specific language, if you break down what the law says, it says 2 or more members. Origin is traced to some legislative action. Now, it can be an ordinance, a resolution, or really just a motion to create a committee. Any one of those things, and boom, open meetings applies. The name of the body doesn't matter. If you call it a work session, hey, still an open meeting. Doesn't matter. Doesn't matter what you call it. If you call it a scheduling or agenda session, still an open meeting. So what's interesting, we like to look at what other governments have done and learn from their mistakes. So I'm going to pick on Knox County because, you know, they're a county. Knox County, about 15 years ago, they had a problem come up. Have a charter form of government, which most counties don't have, and they had term limits. Well, term limits have never been enforced in Tennessee, and they weren't sure that they were legal, even though the voters adopted it in their home rule charter. So people ran for a third term. You know, under the charter, you could only get 2 terms of office. Well, half of them ran for a third term, got reelected. And so finally, when the city attorney said, you know what, I think we might have a problem with these term limits, you all need to, I think you really need to resign and they need to replace you. Well, they all decided to huddle out in little groups when they adjourned and decide who they were going to appoint to their soon-to-be vacant positions. And the position they took was, well, we didn't have a quorum, so we didn't violate the law. The way the law is written, you got to have a quorum to violate the law, so as long as we don't have a majority of us out here doing something, we're not violating the open meetings law. That was such a losing argument. The county attorney made it anyway, but yeah, they lost. You know, they had come back into that meeting and immediately appointed the people they wanted to take those positions. Citizens sued, and the citizens won. Now, so you can't just say, hey, as long as we only have a couple of members, we're not violating the open meetings law. So Knox County gave us some good case law that says, you know, it only takes 2 people on a governing body to violate open meetings. So just keep that in mind, that defense of you got to have a quorum didn't turn out so well for Knox County. Yes, sir, absolutely. Okay. I'm going to get into enforcement and consequences in a minute. Yeah, it's very easy to cure a violation, so we'll get into that. So we've talked about what is a governing body, and you know it definitely doesn't have to have a quorum to violate it. So the next part of the analysis is, okay, what's a meeting? And you would think that would be pretty easy to figure out. But for the purposes of the Public Meetings Act, it's public meetings, open meetings, sunshine law, whatever you want to call it, a meeting is any deliberation. It's not just a, hey, we're all going to get together and meet here in this location today and it's all going to be open. If you happen to run into one of your fellow board members and y'all decide to sit down on the park bench and have a discussion about pending matters, guess what? You've just had a meeting. You've just had a meeting. So be aware of that. It only takes 2 people in passing, discussing either what may be pending before your board or what you anticipate could soon be pending before your board to violate the law. So deliberation, they say it's not fact gathering. So if you can in your mind separate fact gathering from deliberation, then you can make a site visit to another city to check out their ballparks. You can make a site visit to another city to check out their public works. Or, you know, the group themselves go check out a new city project, see how things are progressing. And y'all can look at it and get information about how things are working. But once you start talking about it and say, well, you know, I'm not really happy with the way this is going, and maybe we need to make these changes, and, you know, a change order might be needed for, you know, once you start talking about it, you violated the law. So those little fact-gathering trips, or we also talk about retreats. We have some governing bodies, believe it or not, who just don't get along. And they need to go outside the city to a retreat to work on their relationship. That's not a meeting. But, however, here's our caveat. MTAS says go ahead and give notice anyway and invite the public. Because then, if you do end up deliberating when you didn't mean to, you haven't violated the law. You gave notice. So if someone complains, hey, we did give notice, you had the chance to come. So that's one of those best practices things that MTAS tells you to do. Legally, you don't have to invite the public to come with you when you go visit the sewer treatment plant. But why not? If you don't invite them, that's when they're like, oh, what are they doing? If they see the notice run in the paper, they probably really don't care. It's all about whether they think you're interested in them being there or not. Okay, notice. That's another aspect of open meetings, of course. the notice of the regular meeting. So I'm going to get into a couple of new laws that passed last year that impact this. We do have one now on agendas that I will go into. But this is all the law says about public notice. Adequate. Adequate. Do you think what's adequate in Franklin is going to be adequate in Ridgeside? So we have case law. We have a Memphis Publishing Company versus Memphis 1976 Supreme Court case that explains, looks at the totality of the circumstances and notice which within that community is going to reach the most of your citizens. So in every city, the notice should look a little bit different because all of our citizens are different. In some of our small towns, people hang out at City Hall and they actually go to the utility department to pay their water bill. Those are great places to post notices in those little towns. Always do it on your website, but the website itself can't be the only notice. 20 years ago, Oak Ridge was like, well, we can just post it on our website. Everyone in our town is on the internet. And I said, that's not sufficient because there's going to be one or two people out there who are not. So we do have Attorney General's opinion saying that website posting alone is not enough. We also have small towns out there that, they do what every city does, and they have an ordinance that sets their meeting schedule for their governing body. We meet the second Tuesday of every month at City Hall at 7:30. And a lot of our smaller towns thought, hey, that's notice. Well, it's not, because they need to know what you're going to be voting on. So I'm going to get into the agenda law and the new requirements around that here shortly. But adequate public notice may look different for every city. MTAS suggests you have 3 different methods of delivering notice, and I know that Franklin does that very well. And it's good to stick with the same notice postings so that you have a clearly established record of this is just how we do notices. And I know Franklin's on top of this. So the next issue that comes up is special called meetings. If you've looked at your charter at all and you understand a little bit about city charters, you know that there's a lot of cities out there that have very funky charters. We have cities with charter provisions that say they can call a special called meeting with just 24 hours notice. I don't like that. I do not see a time period in Franklin's charter for calling a special called meeting. MTAS does recommend you give at least 3 days notice. We think that that's optimal. And again, post it at 3 different places. But again, a special called meeting is just as the title assumes, it is called for a special reason. So the notice of the special called meeting has to state specifically why you are meeting, and then you are limited to only discussing what you have stated in your notice. You can't go further. You need to be specific. I've seen some special called meeting notices that said, well, we're going to discuss the city manager's performance. Okay. Well, they got together and they discussed the city manager's performance, then someone called for a vote to terminate the city manager, and they did so. That wasn't part of the notice. The notice did not say they were going to vote on what they learned about the city manager's performance, so they violated open meetings with that. They did not provide adequate notice of what they were going to do. So be as specific as you can when it comes to special meeting notices. You've got to, and only stick to the agenda there. So this is the new agenda law that went into effect last April. I have always advised cities that it's best to publish your agenda before a meeting, because how else is the public going to know what you're going to be doing, So now it is a codified requirement, and I'm sorry if this causes problems for some cities, but in terms of letting your citizens know what you're doing, it just makes all kinds of sense. So 48 hours prior to the meeting, you are to post your agenda. And if you have a website, you have to post it on the website. But that can't be the only place you post the notice. And I'm sure Franklin has this well under control. The law does say you can take up matters not on the agenda. This question comes up all the time for me. Can we do anything that's not on the agenda? And the answer is, it depends. One of those slippery legal answers. So my answer is always, well, what are you voting on? Is this an amendment to a zoning ordinance that you all are thinking about, sending it over to Planning Commission and pursuing, or is it something dealing with taxation? If it's anything that's going to raise eyebrows, you better make sure it's on the agenda. But if it's something like, well, we want to adopt this resolution recognizing the Boy Scouts for doing something, okay, go ahead. If that's not on the agenda, I don't think that's going to cause a problem. So be very careful about doing anything that is not on the agenda that the public has notice of. Again, you got to look at the nature of the action and how many people would be upset if you did this without giving notice when you make that determination. Now, the statute specifically does say that the city can have bylaws adopted, Robert's Rules of Order. If you follow that process, you can add items to the agenda during the meeting that the public does not have notice of. But again, from a risk management perspective, be very, very careful about that and take all your cues from the city attorney. They do have some language in there about not circumventing the spirit of the act. I think what this means is knocking things off the agenda because a bunch of people showed up and you don't want to talk about it. Lay that sucker on the table. Now, you know, laying it on the table, or, hey, let's just postpone this for further study until the next meeting, you know, you can do that. But the third or fourth time, you're going to get someone's attention. So be aware of that. Any questions on this new agenda law? Yes, sir.
What about on the agenda, other business?
Okay, the other business portion on the agenda. If it's just in terms of informing the city about something that may be coming up, okay, this new business, hey, we have this contract in front of us, we're going to be discussing this further at our next meeting. I mean, it's fine to do that. I would really hesitate to have a governing body vote on anything under other business. I think that's bad policy there. But bringing up something and plans for the future and something you may entertain at the next meeting, that's what that's for. I don't think it should be subject to a vote, though. Yes. Do you agree with that, Shauna? All right, there you go. There you go. Okay, this is the other new law we got last year, public comment. Public comment, because you know, so many people just come and really enjoy attending your meetings. They want to participate. So before this law, you know, my position at MTAS was open meetings just says they get to attend. Doesn't say they get to speak. And so you can imagine over the years, we have towns that always have on their agenda, and I hate that they say this, a section for citizen grievances. It's never, it's never citizen compliments. It's citizen grievances. Yeah, generally something not on the agenda. It's basically wide open. And so, but you know, one of the bad situations is like in Gatlinburg after those fires, they couldn't hold public meetings because all the citizens showed up and all the citizens had grievances, and by golly, all of them wanted to speak. So they were meeting till midnight, just getting browbeated over their failure to prevent the tragedy. So a lot of cities got rid of the citizen grievance section of their agendas, and their meetings started going a lot better. And then last year, General Assembly threw us a stick in our wheel pockets. I can't even say the bike thing right now. Anyway, they screwed things up for us by saying you now have to take public comments. So now the public gets to participate in your meetings, unfortunately. And you know, it's good if you control it. Now, what the law says, you've got to have public comments unless you're talking about punishing a member of the governing body or someone who reports to the governing body. You don't have to allow public comments then. And it says a meeting where there's no actionable items on the agenda. What does that mean? Actionable items is not defined in the law. Now, we went back last year and listened to the legislative history. The sponsor of this bill was asked, if he should define that term and if he meant voting. And he said, no, I don't mean just voting. I mean any action. Okay? So that's every single meeting. That's every meeting. But Open Records Council disagrees with me, and she's the gatekeeper. Tony Chadwick is our Open Records Counsel for the state of Tennessee. Now, Tennessee Open Records Council also is the head honcho on open meetings issues. It is her opinion this only kicks in when there's going to be a vote, because to her, actionable item means voting on something. You can rely on that if you want to, and she's the Office of Open Records Counsel. I am more risk adverse than that, and to me, deliberating is actionable. So I would advise cities, when I'm asked, just have a public comment period for every single meeting. Don't fight it. But that doesn't mean you give up your meeting to public comments. A lot of cities have started adopting resolutions, setting time limits not just on how much each speaker gets to speak, but a total amount of time they're going to take public comments period, after which they will cut it off and end the meeting. So for example, Metro Nashville, 2 minutes per speaker, they take a total of 20 minutes of public comments per meeting, then it's done. Then it's done. Now the process they have is pretty, you can go online and see it, but they try to make sure the same people aren't signing up every time. So you know, when I mentioned the agenda earlier, you all need to put something in the agenda once you have this policy in place, telling people how they sign up to speak during the public comment period, and set a limit on just how many speakers you're going to entertain that day. So I know that Sean is on top of this and your legal team. This is something that is very manageable if you've got the resolution and the process in place, and you have an executive running your meetings that will enforce it. We do have problems in a lot of our smaller cities with, you know, part-time mayors who are chairing. They just don't know how to cut off that 90-year-old woman who keeps talking about her garbage pickup, because they know they're going to get really mad at them. So it takes a lot of work from the chair of your committee and board to enforce this, but it is something you can enforce when you set those limits in place. Yes, ma'am. That's why. Mm-hmm. That's why it's important to have a good policy that is well publicized, so that people know, hey, we're only going to hear from 10 people in this meeting. You put that in your notice. This is the sign-up sheet. And then you have a policy where if someone has spoken at the last 2 meetings, they don't get on the list. You put someone new on the list for comments. Right. So you're not hearing from the same people. Now, first of all, I want to make clear, this does not apply to public hearings. Public hearings that are called for zoning amendments and public hearings that are required by our state law before you do things, this doesn't apply to that. So public hearings, the whole purpose you're there is to talk to the public about it. So I can understand having some some restraint so someone doesn't talk for a full hour, but you shouldn't be cutting people off after 20 minutes total of comments in public hearings. Public meetings is different because the public meeting is your time. Okay? Now, one thing to remember, the one limiting factor on this in terms of, I've talked about you all having a policy to limit the amount of time for speakers and then having a policy that limits the total amount of time you're going to spend on comments. The other thing is you can limit them to items on the agenda. So that's an improvement. They're not just going to get up there and just yell and scream at you about nothing or something that they got up on the wrong side of the bed that day. It's got to be something that's on the agenda. So we do have that ability. So your question, okay.
Public comment, there's where they still get to speak to the item and they're not disenfranchised.
Right. Exactly. And so that's why when it's things like zoning amendments, oh yeah, those property owners, everybody come in and talk. Right. I wouldn't. I think you can set a reasonable amount of time, like say, hey, we're not going to spend more than 3 hours on this. But, sometimes when citizens are angry, that extra hour can make all the difference in the world. So that's the kind of thing that your chair and your body needs to decide in consultation with the city attorney. All right. Yes. Right. Right. And so your sign-up sheet for people to sign up to make public comments needs to have a statement up there quoting the statutory language saying it needs to be about items on the agenda. Well, you can't. You can have everything wide open if you want, but a controversy arises in your city, you're going to be there till midnight. So I think it's a good idea to get something in place that everyone understands and really publicize it. Your community will be able to comply and understand. I mean, Nashville's been doing this for years, and I hate pointing at Nashville and saying, look what Nashville's doing. But honestly, consider how big Nashville is. They limit people to 2 minutes and then 20 minutes total per meeting and then move on. They've been doing that for years, and no one sued them over it. So that's legal. But they also make sure they don't hear from the same 10 people every time. And you have to be sure in doing this that you are viewpoint neutral and that all sides are heard. You don't just get the pros, the people who want to compliment you, up there giving you comments. I know they exist. They do attend meetings sometimes. Okay, any questions on this new law? We're going to be watching how this proceeds, but this is certainly something that cities are struggling with currently and trying to decide what types of restrictions will work for their governing body and with their community. Well, the way it is working, that I've seen the cities do it, they just make sure the same people aren't speaking every time. And that winds up with them getting some different viewpoints. The same person is probably going to take the same position on most issues before the board. Just don't do it, period, those people. So you just need to make sure that, others do as well. Now, if you have comment periods and every single person is saying the exact same thing, you may need to wonder, okay, was there an opposing view that we didn't reach? And were there people who didn't get this notice and understand they could sign up? And then you might need to go back and reevaluate at that point. Yes, ma'am.
When the chair asks if we are getting 10 of the same views, can they ask, is anybody on these cards who are speaking have opposing views?
Absolutely. Now, her question was, if you hear from 5 or 10 people who are all saying the same thing, can the mayor just say, hey, is there anyone out there who has a different opinion? Absolutely. And then the mayor could say, hey, we've heard from 5 people on this side of it. Any of the commenters signed up have a different viewpoint they want to express? No? Okay, we're done. Yeah. Now, to me, though, if someone has actually put their name on that line saying they want to give a comment, you need to let them give the comment if they really want to. So if they came up with a speech and, yeah, I agree, Mayor, but I had some really important things I wanted to say, yeah, give them their 5 minutes or whatever is provided in that meeting. So again, it's interesting to me that when it comes down to it, this is really about communication. And I think as a society, we don't communicate as well as we used to. But, you know, a good, smart mayor who understands his community and can communicate with them about it, this is really something that is not going to be hard to comply with once we get used to it. It's just new right now. Okay, he's mentioning the red, blue, and green T-shirts and getting the point across quietly without even speaking. Yeah, I'd say Franklin has some experience with that. Any questions on this before I move on? Okay. So I had the question earlier about enforcement. Any citizen can sue a city for violating open meetings, and they sue the body and then they sue the city itself. But what happens is if you violate open meetings, the actions you took are void and null. And the only time this doesn't wind up in that spot is if it's debt. If y'all vote in a contract and you vote in a bond issue and that's already done and, we violate open meetings, you can't undo that because the banks are going to make sure they don't get screwed because somebody messed up. So otherwise, it's just null and void. Now, what happened to Knox County when they lost their open meetings lawsuit, they had to report to the Chancery Court for a year on how they were now complying with the law, in addition to paying attorney's fees. So we don't have we don't have penalties like fines built in. We don't have large judgments for damages because, okay, what's your damage? But we do have a provision that the city may pay attorney's fees if it was willful. So that's a possibility. I don't see that happening in Franklin. I mean, you all have Shauna and her whole team back there to keep you in the lane that you're supposed to be in. But our smaller cities struggle with this, and usually it's because, you know, they saw the members talking in Walmart. Maybe they recorded them and took video. Amazingly, we have governing bodies out there with spouses, both members. I mean, I tell them don't do pillow talk about city business, but hey, you know. So this can be challenging. It can be challenging. Yes, sir. There's the cure. I disagree with that. Okay, what he's saying is, hey, they're going to cure it anyway in the meeting, so don't worry about it. But you're intentionally deliberating outside of a meeting. I would still avoid it, no matter what. Just avoid it. Uh-huh. And you make a good point. This is why we don't see a lot of open meetings lawsuits, because the violations are easy to solve. But that doesn't mean you can just violate the law. The courts really look at the intent. So if I have an official in here saying, well, as long as I repeat myself in the next meeting, it's okay, the courts will eventually get you for that because they look at intent and willfulness. And if you set out knowing you violated the law, you're going to pay attorney's fees. I really think so. Now, so the cure is just a substantial reconsideration. That's what the court opinion says. So we also have a case involving the Nashville Zoo that went into this, and they didn't have a record that showed they deliberated, so they had to go back in and create a record showing deliberation on a zoning amendment. So your record needs to show substantial reconsideration. Now, what I used to tell local governing bodies, well, I used to tell city attorneys years ago, emails. We had a lot of governing body members back in the early aughts who were kind of new to the internet and decided emails were just the best thing in the world to communicate with board members and send articles and materials back and forth and discuss things. So our advice to those city attorneys was you print those emails, you read them in the meeting, then you attach them to the minutes. Governing body members didn't like that. But you know what? It made them stop sending those emails. Now, it doesn't matter really, well, it does matter if your email contains discussion. Just forwarding an article or forwarding materials to other governing body members, that tells them what your position is on it. They're going to be able to tell if you're pro or con based on that attachment. So just don't send emails to each other. Just don't do it. It's one thing if it's administrative and okay, remind me of the meeting time and where I'm supposed to go. And hey, have I gotten my packet of materials for this meeting yet? Okay, that's fine, but don't talk about anything else by email or in person. Because really the very best thing to do is to read those emails out in the public and attach them to the agenda, and I don't think many of you all want that happening. Yes, ma'am.
Okay, I think big issue, huge issue. Because this is like the state legislature saying, do what we say, but don't do what we do.
Amen.
And I'm frankly sick of it because it hampers everyone's jobs to be more effective for the public. So a lot of times if there's an article, it's not one-sided, it's just information. And if I'm reading something and I think, oh, the alderman needs to read this, the city administrator needs to read this, the mayor needs to read this. Sometimes I have said in the past, here is an interesting article, maybe get both sides to something. It may not even be something we're voting on. It may just be generally about transportation. It may be generally about sustainable cities, okay? And I say, but I always put in there, not for comment, do not reply. Now, I think I've covered my derriere by doing that, but also do I need to print that out and say, hey, I sent this out earlier to everyone for their information?
Depends on what it's about. Did you all hear what her comment was back there? Okay. If it's something that's not on the agenda, and you don't think it's going to come up in the next month's agenda, I think you're fine doing that. But if you're getting ready to vote on, say, a transportation plan, and then you start finding transit articles to send to other board members, at that point I think you're getting into deliberations. So is it pending before the board or not, and do you expect it to come up shortly or not?
Okay, so if that is coming up, and I
Mhm.
agree with that, I see that, and I don't disagree with that. But if that's coming up, and it's a great article that we should all be reading, our city administrator said, send it to us, we will send it.
Yeah, and that way it's like you're including it in the packet of materials that everybody gets to consider for the issue. So it's not like hey, this is the article that this board member wanted to be sure you read. So that's perfectly fine.
And I think another example is like I'm on the Sustainability Commission, and there may be something really interesting about recycling.
Mhm.
And I think the board should read that because we get reports periodically from the Sustainability Commission, and maybe a year or two from now, we will have a decision to make again on recycling. But I want them to read that.
Yes.
But I always say, not for reply, but for your information. But as you said, if it's pending, send it.
And you know, reports from work committees like that, that's a little bit different than, you know, the article you see in the media that you send. That is informative, and I think providing that type of information does not get into deliberations. But you see here in answering these questions, it's all very fact specific. Very, very fact specific. Yes, sir.
As board members, I send a weekly update to you all, so if there's something
that is never a problem to me. If you want to just send me something, say, hey, I think the board would benefit from seeing that. I'm glad to include that. Or if you're like, hey, we've been talking about this, or this is coming up on an agenda, this would be good to include. We could include it in the packet as well. So don't hesitate to let us know if there's something you think we can help facilitate. Instead of you having to send it out, we can send it out either through the regular updates or as part of the agenda, assembly process.
Excellent.
One of the things I was going to say, I think staff has worked as well with this board done, is we never really deal with our commissioners. They're all in one copy. We spend really just one file.
That's awesome.
And, you see that in other places where they don't do it that way. And they don't.
That's my pet peeve, the reply all. Ugh. Ugh, reply all. Please don't. Thank you so much for that. I want to discuss the Nice versus Paris Special School District case with you for just a few moments. This is the case that makes MTAS give the advice that you provide notice when you go on retreats or do workshops, or even when you're doing field visits. Technically, it's not required, but this case taught us that it's always best to do that. Paris Special School District had been arguing for many years over a clustering plan. Now, I don't work with boards of education, so I don't really know much about clustering plans. But apparently it was very, very controversial. They had fought bitterly in many meetings about it and could not reach a resolution. They decided to take a retreat. They went to a park up in Kentucky. They said, oh, let's leave the town, let's leave the state to do this. Okay. But they are working on their relationships. Well, then they came back in the next meeting. They discussed it for about 5 minutes, and suddenly they had an agreement and they passed the matter. So the press had been watching them. They're like, hey, what happened in Kentucky? There was apparently something more that happened there besides just, shaking hands and getting to know each other. So they sued, and they won, because clearly deliberations had occurred during that retreat in Kentucky. Maybe they didn't intend to do that when they went on that retreat, but inevitably, when you're sitting there talking and spending time with fellow board members, are you going to be able to resist talking about something that you shouldn't? And if you don't, you violate the law. So this is why we say, okay, we know it's a retreat. We know you're working on your relationships. You're not going to talk about city business, but go ahead and give notice. Invite the public. They're not going to go to Fall Creek Falls. And if they show up, it doesn't mean you got to give them a hotel room or feed them, but just invite them, and then no one's going to care. Anyway, so that court opinion is the reason why we give that advice. Yes, ma'am.
So let's just say that myself and Alan were out, and I will say we were very good, myself and all of us, we don't discuss because of this very big shaman thing, very big things. But let's just say we have a discussion accidentally about, should we then report it to Shauna that, hey, we were out somewhere and we had a discussion about something that's coming up. We then report that and then it's made known at board. That's how
Yes, ma'am. Yes, ma'am. And
Disclose it in the meeting. You don't just tell Sean. You need to disclose it in the public meeting. So that everybody
you do, but I would talk to Shauna to be sure that you go about it the right way. Yeah. Yes. Yes. But, if you did that 1 month and then the next month that item did show up for vote, yeah, that was a deliberation. Yeah. Again, you are the model city as far as I'm concerned. But did everyone hear her question? That if she did, without intending, you do end up talking to a board member about something, the first thing you do is you tell Shauna, and then the next meeting, you repeat that whole discussion on the record. And you can discuss with her whether or not you announce at that time, hey, I had some discussions outside the meeting, so we're going to fully discuss this. Or if you just fully discuss it and don't mention, I violated the law. Yeah, absolutely. Thank you for such a great question. Okay, executive session. Remember our first slide when we said all meetings are to be open except as provided by the Constitution? This is what it's referring to, attorney-client privilege. But it is a delicate, delicate dance. I've had attorneys from other states that come in and work with Tennessee cities who are just blown away that they can't call executive session to talk about liability and risk management. You can only go into executive session in Tennessee if there is a lawsuit pending or a lawsuit is threatened. So I tell city attorneys, if no lawsuit's been filed, hey, call them and ask them to send you a demand letter. Then it's a lot more clear that you can go into executive session. We haven't had a court opinion where a board has met without a demand letter or lawsuit and they've expressed that that is a requirement. That's a risk management perspective that I take, that I think protects our cities. So within the executive session, you can't deliberate. So the purpose of the executive session is for the governing body members to hear from the attorney about a settlement being offered, to hear from an attorney about the likelihood of success in this lawsuit and trial strategy and how things are going, and to ask questions of the attorney. Once the board members start talking about, well, I'm not sure if this is a good settlement amount or not, I don't know, you're deliberating. You got to do all that in an open meeting. So you got to air your dirty laundry. But now some city attorneys have gotten really great at this, where they're very specific in their executive session, and they will say, okay, well, we can go out and discuss X, Y, Z in an open meeting. We need to do that to have our vote. But it's all about the exchange of information in that executive session as to how much dirty laundry has to be aired. It's a very delicate dance from city attorneys. A lot of people still have the assumption they're meeting with the city attorney, it's executive session, doesn't matter, they can do whatever. That's just not true in Tennessee. We're very limited on what we can do in those meetings. So take all your cues from Shauna on this, but that's going to be the only time when your meetings will not be open. And that all comes from case law. So once you start deciding what to do with the information your city attorney has given you and you start discussing that, that's got to take place in an open meeting. Okay, any questions on that before I get into records? All right. Is the coffee kicked in yet, or am I really not confusing you? All right. So our law, our public records law, you know, we're just so transparent and wide open in government in Tennessee because it's all for the citizens, which is true. It's all for the citizens. It's really hard to convince city employees that those are not their records. These are the public's records. I mean, sure, you may have half of your career in that 3 filing cabinets over there, and you may have created every document in there, but that's the public's record. And your job is to give it to them when they want it, period. And so the law says that all city records must be open during business hours for inspection by Tennessee citizens, period. Well, unless otherwise provided by state law. Now, as a reality, there's some federal laws that kick in as well. I mentioned the Office of Open Records Counsel earlier. They are certainly the lead on this. The Attorney General does not issue opinions on open records, well, unless the legislature wants it on a specific matter. But Open Records Counsel is the primary top dog in our state on all open records issues. Great resource. So it goes into describing what form a public record can take. You know, it's a document, it's a video, it's film, sound recordings, anything that comes into City Hall and that you receive as part of your duties for the city or employment with the city. Pretty much every single thing. Now, this official business by governmental agency. You know, a lot of people say, well, you know, that was my personal email account. I was just, where they're working for the city, they're on the clock, like a firefighter. Well, I was just on my social media doing X, Y, Z, and I did post something about X, this, and that, and yeah, I sent a couple of emails, but it wasn't working, I was on break. They're on payroll, you're getting paid for that time. Guess what? You just created a record. You just created a record. It also doesn't matter which email address you use. If city employees use their personal email to do city business, guess what? Their personal email can be sought in a records request. If you use your personal cell phone and send text messages and do a lot of city business through your personal cell phone, your personal cell phone, the text messaging and information on it may be subject to an open records request. The problem for smaller cities is they don't have much equipment, and their own employees are bringing in some equipment and creating records. Again, made or received pursuant to law or ordinance or in connection with the transaction of official business. The official business words in here don't mean anything. If it's an employee and they're on the clock, they're creating public records, whether they're doing their personal emails or what. If you are a board member and you're traveling or you're receiving documents, you're making notes during meetings, those are all open record, every single one of them. There's a man who is the head of the Tennessee Fire and Codes Academy. His name is Jeff Elliott. And I met Jeff in, I think, 2005 or 2006. I started teaching the fire chiefs orientation program. I go in, I talk to fire chiefs about legal issues because there's just not a lot of attorneys out there to answer questions for them. And most of the fire departments that serve our cities are volunteer fire departments. And they're, most cities don't have city attorneys like Shauna. Well, no city has a city attorney like Shauna except for Franklin. Right. So they don't have someone they can call. So I've been doing this class for, oh gosh, it feels like 30 years, but it's probably been more like 15 or 17. And one issue we see with them is they all use their personal devices. I'll have a fire department and I'll say, hey, do you all have helmet cameras? No, we don't. But 3 of their firefighters will. Because anybody can go on Amazon and order a GoPro camera, right? So the problem we see in fire departments is they're taking photographs and video with their personal devices and the chief has no idea. So when they get a records request, they got to go to those firefighters. Well, hey, did you take any photographs at the scene of that accident? Because a records request comes in, even if you don't have it in your possession, if your employee does, it's a record that you're going to have to get and provide. Now, Jeff Elliott, he was a captain in a fire department, a very professional fire department in a very wonderful city. And there was an accident that his department responded to. There was a fatality. And his department responded. Some months later, there was a lawsuit filed. There's a wrongful death claim. And the attorney came to the town and said, I need to see the photographs taken at that accident. So Jeff went and asked his people, looked all over the fire department, looked in the file. We don't have any photographs. Well, okay, he gave them whatever was there. And the attorney kept saying, no, you've got some photographs you're not giving us. And Jeff said again, he went and looked again. No, there's no photographs. We don't have any photographs. Turns out a firefighter had taken a photograph. And this firefighter, unknown to Jeff, well, I think he knew at the time, he taught CPR classes in first aid. And he used that photograph in a presentation, and I think it was along the lines of, some accidents have a medical cause. I believe the person who was deceased maybe had a heart attack. There was a family member in that classroom. So they knew the photo was out there. Jeff did not, because it was the employee who had it who didn't give it to him. But what happened to that employee? He had to turn his phone and his computer over to the court. And I understand they kept his laptop about 3 months, and his phone for weeks. The judge went through all of it to see what is open and what is personal. So when you use your personal devices, that is the potential consequence you face. Now, if, again, this happened to Jeff Elliott and his department back in the late 90s. I mean, we were on flip phones then. I don't think I'd even seen an iPhone at that point in time. And that little flip phone, I don't think I could have done a video on it, but still, 20 years ago, this was a problem, and it continues to be today. What I advise fire departments now is for each fire chief to talk to the firefighters and create a Dropbox or an email account where they send all the photographs and stuff they take when responding to an emergency or when training or whatever. If they're working for the fire department, you make photographs, you send it to this email account so I have it if a records request comes in. Okay. All right, so of course Franklin has a public records request policy adopted as required by our state law. These are the requirements that we have within it. I've been on your website. It's excellent, and you say you limit it to Tennessee citizens. So right there, y'all have made the right decision. We have some cities that have not adopted policies that say it's limited to Tennessee citizens. So under their policy, someone comes in from Mississippi, well, yeah, I guess they're entitled to it, but they end up having to argue over it, which is really a shame. But a lot of people are very familiar with our records law now, and despite the fact they may have a lawsuit pending against the city or be your clerk's very favorite person that shows up every day asking for records, they still have the right to do that. Now, we do have a process by which we are able to charge labor when certain conditions are met. That is something Shauna can help you with, but Office of Open Records Counsel, they have a best practices guidance document that really helps a lot. And if any of y'all deal with records, I feel for you because I know this is hard. Those of you who do not deal with records, please be aware that the employees of your city that do, they have a very difficult job because they have to respond quickly. Yeah, the law says you got a week, but you don't have a week. You have a week if it's complicated and you're actually going to have to take a week to produce the copies or set aside the time for them to inspect. So don't take the full week. We've had a city that decided they didn't want to give someone a record. They had the record available. They made them wait a week. That person sued. They had to pay their attorney's fees because they made them wait a week when they didn't have to. So just like the open meetings law, the open records law is geared entirely to access of citizens. Entirely to access of citizens. And our law is not ever caught up with reality. Meaning, when I first came to MTAS in 2001, there wasn't even language in the public records law that protected Social Security numbers. So, people were getting accident reports and citations copied that had Social Security numbers on them. And I would say, well, I don't see anything in the law that says they can't get that, but I don't feel comfortable with that. Well, now we have language in the law that says you redact that information. And there's a long list of information that's redacted when a personnel file is requested. So your records clerks are dealing with that every day. Please extend them some grace when you need something from them because it's a pretty difficult job, really difficult job. Any questions on this? Okay. Now, we do have the records retention schedules at MTAS. Shauna, have you all adopted the resolution? Records retention instruction? Okay, so there's a process you need to be sure you follow where you document destruction of records under the schedule that we have on our website. I've had some cities that just never want to throw anything away. That's fine, but as long as you keep it, you got to produce it. So, phone logs and E911 center stuff. The law says you keep that for 5 years. Our retention schedule says you keep it for 5 years. Some want to keep it for 10. Hey, yeah, you can keep it for 10, but if someone comes in and asks for that report that's 10 years old, if you still got it, you got to go find it and copy it. So the records retention schedules helps to free up those clerks to only keeping them for the amount of time they have to. And so that helps to make it a little bit more manageable. If you want to be one of those cities that keeps everything, but you're going to have to produce everything. So we highly recommend following the schedules. Shauna will give you guidance on that. There's forms that we recommend to document it so everybody knows what's being destroyed. We don't want anyone to get in trouble for getting too enthusiastic and destroying stuff without authorization. So be sure you go through your records request coordinator and maybe Shauna to be sure when your department or your board does a clean out of files that you comply with the city's policy on that. Okay, well now I'm going to do legal dodgeball. I will take questions. I know that I probably left you with some questions here about these laws. Stephanie O'Hara, my co-counsel, would say, don't go beyond open records and open meetings because that's all you're talking about today. But frankly, if you all have a question, I'd be glad to answer it.
I've got a mic back here. It doesn't make noise in this room, but it makes noise on the recording that we're making. I will also say this slide before this one, we're talking about record deletion and throwing things away. That also means your cell phone text messages. So you can't just delete text messages because you've had them back and forth and you want to get rid of them. If you do, you could also be in violation. So look at what you're texting about. If you're texting about a contract or something like that, we have to keep records for a really long time for contracts. Same thing with employees. So just be thinking about that.
Yeah, and also in discovery, we do have a rule of civil procedure discovery on emails and electronic communications and preserving information. So yeah, that's why you need to take your cues from your city attorney on those matters.
Anybody want the mic? Any questions?
Oh, come on. There you go.
Sorry. Okay, so for people who sit on a board and they bring this may be more for Shauna than you, but they print out the agenda and they print out some of the packet materials. Do they have to preserve those? If they take notes, if they take notes, that's different, but if they're just like, I make a policy not to really write on anything like that because I haven't wanted to preserve it. But
if it's a packet you haven't taken notes on and the city has the packet they
Right.
keep at the agenda, I wouldn't worry about that. Once you start taking notes, you're creating a record. Now, there's a constant issue of what's a working paper. So a working paper, it includes your notes, drafts, etc. But once you had the final draft of the contract, final draft of the minutes, then you get rid of all your drafts. You don't have to have the drafts once you approve your final official version of it. The same is for contracts, but I see some cities keeping drafts of contracts because they anticipate there might be litigation, and the attorney says, okay, technically it's a working paper, we can get rid of it, but I think it's best that we hold on to this. We may need it in the future. But your notes, absolutely you're creating a record.
yeah. Right.
After the meeting, he would say, I want everybody's notes. And yeah, he did that at every meeting. He would want everybody's notes. So we would have to collect all of them, copy all of them, and then give them to him. And that was something happened every single meeting.
Mm-hmm. And this is problematic when it comes to like hiring committees. Please don't write down that you think she's attractive. I don't want to hear about his blue eyes. So you got to be careful what you write down. So every board member needs to be aware you're doodling your notes, those little things you write when you're angry, and if I write this, maybe I won't yell. Someone can see that. And technically speaking, you're not supposed to destroy it. You create a public record.
That's right.
So be aware of that. That's all bodies. Hey, if your city attorney doesn't know it exists and you're not sharing it with someone, and I just didn't hold on to those notes. Okay, maybe that's defensible, but I guess I've given you notice in this meeting, so yeah.
And a lot of what we give you now is electronic. Before we had packets. Planning Commission had big packets, and BOMA had these big packets. You came in and you picked all your packets up, and people would write on them, and that you could watch people up there writing on it. And so, obviously, the media wanted a copy of it.
We also used to have a filing cabinet equipment.
We did. Yeah, that's right. You could put them there.
There are some people that I've seen doing
they're creating a record.
Yeah, you're creating a record.
So if someone requests it, even though it's in their purse and in their car, not brought into City Hall and put in a file, it's still a public record that will have to be produced.
Yep.
So be kind. Yeah. And you know, it may never come up. Yeah. But as Shauna pointed out, it's the press that wants these things. And it's the press that has the pockets to sue you if they don't get it. And so again, it was an adjustment for me going to MTAS. I've been in private practice for 7 years and understanding that all of my emails and letters were open record. So I have to write things with the understanding this may show up in the press and it can't reflect poorly on my agency or myself. And so I'm just very, very careful about everything I put in writing. And frankly, all of you should be as well. That's why I'm off social media.
So I just made some notes today. Does that mean I need to turn them in?
Well, it's up to Shauna. Shauna's the gatekeeper on this.
He called me to talk to me about that. He was like, I'm so sorry.
Oh, and there was a
did.
great comment over here about the General Assembly. Yeah, these laws don't apply to them. None of them apply to them. Yeah, just like that ethics policy you all have after the Tennessee Waltz investigation. You all didn't do anything wrong, but the legislature made sure to punish you anyway, because someone had to be punished. And
Somebody got their saddle because some group or board went and had a meeting outside, and then they all came in with their deliberation ready to go. So
Paris.
it's like the teacher that walks in the classroom and one kid's acting up, so everybody gets detention if they act up. I mean, I thought we were a little bit better than that.
not in this state.
So if we have, is it just notes taken during a public meeting? Because this is what, I mean, if you have a list of things that like follow-up items for constituents and various things, it's not in a public meeting. It's a to-do list.
It's public business, and it's something you're doing because of your position with the city, your office.
So there's no amount of note-taking in or outside of a meeting that is not public.
Except for your grocery list.
Right, right.
Make sure you end it with this next I'm sorry.
Well, that's fine. I just,
Have a sense of humor somewhere.
Yeah, you're right. It's now if it has nothing to do with city business, no, of course. But if you're making notes about something that's going to be coming up in the next agenda, or just some administrative stuff about the committee, people you need to follow up with, et cetera, yeah, that's a public record.
But I would also argue that maybe those notes are working notes, working documents.
Yeah.
So once you follow up and do all the things,
You can destroy that.
you can destroy it.
Yeah. Now, we don't have a court case on that, but you know, that working paper thing is just really confusing.
It is really confusing. But once you've done it, if you're like, I would need to make sure I say this at BOMA, or I want to follow up with this constituent, once you've done all those things, you've
Yeah.
made a new record for all of the things that you made notes about, so you can toss it.
Yes, that's a good analysis.
At the end of a meeting, you throw your notes away.
So at the end of a meeting, you can throw the notes away you took during the meeting because that's over. You don't have to save them.
If you make notes to say, I'm going to say this at this time, and you did all those things, like I want to make a note to say, yeah, now you said it. If you're making, it depends on what you're making notes about. I know we always say it depends, but if you're writing, when it's my turn to speak, I'm going to say this, and then you did it, great.
Yeah.
If you're writing a note to say, I need to follow up with staff about this, I don't really like this, I don't understand this, then
It's not over then.
Yeah, so it's why did you make the note, I guess. So if you created the note so you would remember something that happened in that meeting, then that's a record. If you create the note to remind yourself to get up and ask a question, and you do that, then you can get rid of it.
Your pro-con list is going to be a record.
Right, exactly.
You're debating internally within yourself, listening to people, and you're taking notes on it.
Yes, that's a public record. Absolutely.
Okay. Alderman Peterson had a question And I didn't hear your answer about today's notes.
Well, yeah, I think you'll have to keep these. But that's good. You want to keep them. You should keep them and hold on to them.
Yeah, you should keep your notes today.
Okay, this,
Right on there.
I'm gonna write it in every page.
How many years should we keep today's notes?
Well, our normal is about a year, but yeah, these are like training documents, so I would say that.
But we also have a video record of this record.
Yeah, but I don't have your notes. Really? I don't know what you wrote. And so that also means, like, when you think about if you do have a whole lot of people standing up and talking, maybe you have 20 or 30 people, if you make notes about their appearance, again, this isn't employment, but this is just like at a board meeting, and you're like, this person looks like this, or this person looks like that. If it's, people might not love that if they ask for your records and they're looking at your pro-con list or your notes or who's for, who's against, and you make inappropriate comments. Mary?
Okay. Yeah. Okay, I'm thinking of a couple of things. We're doing design review in historic zoning. And I'm real good at drawing on the thing, on whatever, how I see it could be different. Well, then sometimes I hand that to staff. So does that satisfy it? If at the end of the meeting, just get. Okay. Okay.
If it's better for you to draw it,
Uh-huh.
then explain it, and you've explained it, and
I try to explain it, yeah.
you can destroy that because you
Okay, because you've explained it.
now you've explained it. If you draw it out and then explain it, but not to show it, we really do need to put it as part of the record. But if
Okay.
your brain works in a
That in a very odd way, yes.
We know that, Mary.
Yeah, so, knows that. So, that's okay. Okay.
If you could pass to her.
Okay, so I normally, as a matter of course, as people, especially when we have loads of people in the planning commission come up and they say different things. Generally, I would jot down a person's name, sometimes their address, but as they bring up different issues about something that's on our agenda, I may write down, drainage issues, so that, because, I want to keep in my head, kind of want to keep an open mind. So then at the end, and I'm never one to keep my mouth closed, you can tell. So at the end, I will form, because I'm generally weighing, I will have an idea, but sometimes it will change my mind. So here's the thing. So at the end, I'm kind of weighing, deliberating, or whatever. I'm trying to declutter my life, okay? So I don't want to keep all these notes. We'll have that. I don't want to keep all these notes for 5 or 10 years. So can I just go hand it to staff or whatever? So do you want that? Because I'm generally going to say, I've decided because drainage, so I'll take this and put, so I'm just going to hand it to, because you guys want that, right? Right. Because here's the thing. I feel like I've said the reason that I did it.
Yeah.
Okay, I'll give it to you because I don't want them.
There you go.
Okay.
I'm with you. I don't like
Okay.
keeping stuff
Okay.
either.
Thank you.
Yeah.
Don't give them up.
But if you addressed what's on your notes, you're good. You're done.
Yeah.
Because I feel like it's done. I don't feel. Why would you even want them? It's done. I'm not writing about anybody's appearance. I'm not writing anything secret. I'm just doing it because I need to have all this together. I've already said it. It's over. It's a done deal.
But you can understand why there's the caution, because you can
Right.
also see people abusing the
You
process.
can have them. You can have them. And I'll put my name at the top so you know it's me. All right.
Okay. Any other questions? It is, man. All my questions coming from here.
So I struggle with the concept that the legislature can deliberate between itself and bodies below that cannot. Now, it does lead to a question, though. And I think, and I'm not sure every city is structured this way, but in this city, the mayor is part of the body, and at least cast tie-breaking votes. So what constraints does that put on our mayor in terms of being able to talk to aldermen outside of meetings, in terms of note taking? I think that's something at least you should be aware of, because
Yeah.
that's problematic.
Yeah, all the restrictions here apply to that relationship between the mayor and alderman, even when the mayor is not a voting member, because even mayors who don't have a vote are still part of the governing body for purposes of the open meetings law.
Small request for civic clerk. I take notes during public comments. Right. Well, no. I was going to say, where we have comments right now, if you click on it, I don't think you can capture notes under comments. But if you can put that there, that would allow us to capture of Shauna Billingsley, Franklin said, these things, but allows us to talk through those if somebody wanted to. Yes. Yes. So just make sure that we can do that.
So with technology, there's
Yes,
usually an answer.
anything that you make comments on on the board view of Civic Clerk, which only Planning Commission and BOMA has access to that side. Those things are all maintained within Civic Clerk. So you don't have to make a copy of that and maintain it. We'll keep that with us.
But if your note is so-and-so is for the rezoning.
Oh. The
When they
record.
vote.
Yeah.
Yeah.
Exactly. Exactly. Yes.
But if you said their point was great because of this and, whatever, maybe that could be. But if you're just recording what they said, that is already handled by what we do in covering and recording the minutes of the meeting and the minutes of the video and all the stuff.
Yeah, your recorder or staff member is keeping track of all those things. So.
Yeah, but if you're just tallying how many are for and how many are against. Yeah.
I'm not tattling because I don't care if there's 54 and 30. That doesn't move me. I'm actually doing the issues, right? If they bring up the issues.
Where this has come up in our court opinions is when there have been investigations into complaints in a state department, and the investigators destroyed their records. So this happened under Phil Bredesen's administration. There was trying to remember which department it was, but there were complaints of sexual harassment made, and he sent in a team of attorneys to investigate and interview people. Well, then the Tennessean or some outlet requested those notes, and they refused to turn them over, and then later explained that they destroyed them. Those weren't even protected by attorney-client privilege. So that this note discussion, it's come up in that context. I'm not sure how likely it is anyone's going to care about your all's notes, but we're all interested in good governance and doing the right thing here. So I appreciate the long discussion on it, but I don't know that it's going to be an issue that's really going to come back to haunt you. Because you all are on top of things here in Franklin.
Yeah. Back then we had some allegations and weird stuff going on with, and it, so, and again, when Kevin asked for documents, he also would go through people's trash cans underneath their desk to see what they threw in. Yeah. No, he's good now. He actually understands it, just like John said. Who? Oh, I like Kevin. Any other questions?
Whatever Shauna tells you to do.
Again, it depends on what you're writing. So, again, if you're just tallying notes, then that's fine. But if you're writing something to follow up or whatever, once you follow up, you can destroy it. It really just depends on what you're writing. So if you're confused and you want to follow the rule, you can show me your notes, and I'll be like, just throw that away or keep that. Yeah, but sometimes you're writing them to just when you have. But when you have 30 or 40 people stand up, you forget the first 5 because I know you want to keep notes. I know you want to keep who's saying what. You guys have loads of people that stand up and talk. Any other comments? Any other questions?
Any other questions? Thank you all so much for having me today. I appreciate it.
So next on the agenda, we have Eric. He's gonna talk a little bit about some interactions between you guys and staff and sort of how the city works best. I'm going to turn it over to him, and then after that, we'll get started with another presentation. Eric?
Thank you, Shauna. And I'm going to hand it off to Angie Scarp, too, to talk a little bit about, there she is. I was looking for you. A little bit on some modifications we made on some agenda process, agenda structure. So first of all, I just want to thank you all for everything you do. The electeds and the appointed officials do so much to serve the community, be that connection point, and help us get things done and make important decisions effectively. And just know how much that is appreciated, and appreciate you taking time today to go through these elements to just make sure we're doing it right and how we do our work together. I want to cover just a couple basics. These are things I think the board has a pretty good handle on, but it's just this is a good opportunity to just do a kind of a refresher on this element, especially when it gets to information sharing, research, those kind of components. Obviously, our goal is to help you and be as effective as we can in serving and supporting you in your work. And so there's some things that help us do that. And you know kind of my basic guidelines, but I'll walk through them again. And part of this is how we navigate and manage what we do effectively for staff time, and that we're putting the priorities in the right place. So if you are wanting certain work that will require work, if it's a research project type of stuff, please work through me so that I can get the right people on it and so that they can do that work. And we also are coordinating that with the other priorities that they have. Obviously, if a staff person gets something from an alderman, it automatically goes to the top of their list. That's good, but there may be other things that are also really important. So I want to help them manage that, figure out what the priorities are. Also, again, making sure you may think, oh, that's an engineering issue, so I'm going to ask Paul Holzen about it. Well, it might be a Paul issue, but it also might be a water management issue, a planning issue, a building and neighborhood services issue. So including me helps make sure the right people are at the table to help get you a complete, comprehensive response. So that's not a control thing for me. That is a make sure we're answering the question completely and as effectively as we can for you. If it's informational, it is fine to go direct. Like, when are we repaving streets in Founders Point? Ask Steve. He'll answer that question. Now, if you want to copy me, that's great. And Steve will keep me in the loop on those as well. Staff kind of knows that. You know, when it's more of a broader policy issue, you'll see this. Sometimes I bring it to the work session just to have an initial discussion to see if there's enough interest in the board for us to really delve into a broader, deeper policy discussion. If it's just one alderman's general policy interest, that's probably not a great use of staff time unless there's at least a majority of the board that says, yeah, I'm interested in that. Let's go look into that further. The other thing I always try to work on, too, is making sure there's consistent information shared. So that's what I use the update for, the weekly update that you all get. That's also just something I try to do so that there's not a disparity in what one alderman knows versus another. Obviously, you have different things you have life experiences on, or people you know you've talked about something with. That's reality. But from a staff standpoint, I always try to make sure if one's got something, we're getting it out to all of you so that there is at least a consistent basis of information for what you know and how we're sharing it with you. Again, agenda questions, those kind of things get with me, and I'll help coordinate with the appropriate staff. Again, you all do a good job with this. It's just a good reminder to share with you. We have made some alterations in some support components of what we're doing. The recorder's office has kind of asked us to use this recorder email, recorder@franklintan.gov, to route some basic, typical types of support components. Like, hey, if you're going to miss or be late for a meeting, that's a good place to inform, and then Angie Casey can kind of help route that. If you have somebody that's given the Pledge of Allegiance or doing the invocation at a meeting, just send it through them. We'll make sure it gets on the agenda if it's timely, so that we can recognize those folks. If you got a civic clerk question, you need IT support, you can just send it through there, and we make sure it gets to the right people. I'm always glad to help you with that as well, but that's a good clearinghouse for you in getting that. One thing that did come up today that I want to remind Alderman, we reached out to you a little while back, but if you want a city phone, we will get you a city phone. So if you want to have a phone so that you can route things and use that for city business, we will do that. So just let us know that you want to do that, and we'll get that set up for you. Obviously, we've set up the City of Franklin emails. Urge you to use those too. That's a nice place to keep that separated from the rest of your personal life and other emails that you get there, but that's your choice. And for the appointed officials, I think we've done that for all of you as well. So that's a way to support the work you're doing and not let it get all mixed up with other business or personal stuff that you might have on a personal email. So if you have any questions on that or access on that, let us know, and we'll certainly help you get there. Other elements, just one of the things we are kind of working on that I don't know where we'll get on this, but we have a vision of trying to create a more transparent tracking system for your items that come in from aldermen, so that you can see it and it can be a reference point, so you don't always have to ask back, where is that, or you can see what's been done in response. So sort of an open database type thing that you could go and look and see where that's at. That's sort of a goal we're working on, so that as you get a reference inquiry type of thing, you can come back and look at that and have that help support you in what you're doing. I have one specific question I'd like to ask the alderman to get back with me today before we end this, if you can. We had talked about having a special work session on April 30th for our next step in our strategic planning process. We would talked about doing a 2-hour session, 4 o'clock, 5 o'clock, go for 2 hours to take our next step. From there, if we have that date, then we'll anchor in a follow-up meeting from there as well. So please let me know if you can do that. When we had our group together last time we did the strategic planning work session, that seemed to be the best date. So I'm trying to confirm that so that we can get some things scheduled and get working. It sounded like 4 could work, so let me know on that. 4 versus 5? Okay. All right. Well, let's see what we can do. Get your schedules. We want to keep this thing moving, so we'll get back and start over and see what we can get figured out in terms of a date. Mayor.
Whenever you finished, I was going to ask if you might not let everybody introduce themselves.
Oh, sure.
A lot of the folks that are appointed, the board may have never met them, but they voted on them.
Yeah.
I think that might be helpful to everybody.
Let's just go through the room. I got this. Let's do the one that amplifies. All right, let's just go down the row and say we got both staff here and elected and appointed officials. Let's just go through and do an introduction. Tell us who you are, what you do.
I'm Randall Tosh. I'm the building official for the City of Franklin. So I supervise plans examiners and oversee day-to-day code calls in the field by our inspectors.
Yeah, and don't keep those notes. Yeah, Ken Moore, Mayor.
Michael Orr, Planning Commission.
I'm Steve Dunn, Scepter Engineer on the Board of Appeals.
I'm Harry Harris. I'm the Vice Chair of the Building and Street Standards Board of Appeals.
Hey there, Lee Reeves. I'm on the Board of Zoning Appeals. I'm Vice Chair.
Bev Berger, City Alderman for Ward 1.
Jason Potts, Alderman, Ward 3.
I'm Chuck Barber on the Franklin Transit Authority.
Alma McLemore, Planning Commission, Housing Commission, and Civil War Commission.
Mary Pierce, Historic Zoning Commission and the Civil War Commission.
Marcia Allen, Planning Commissioner.
I'm Ronald Crutcher. I'm chairman of the
Building and Streets Appeals Board.
William Scales, Board of Zoning Appeals.
Eric McElroy, Board of Building and Streets, Board of Appeals, Franklin Transit Authority, and Sustainability Commission.
I'll up your three and give you BOMA, Brandy. Oh, my name's Brandy Blanton. BOMA, FPAC, Franklin Public Arts, Capital Improvements, and Tree Commission.
I can't top that, but my name's Greg Judy. I'm on the Building and Street Standards Board. I'm a registered professional engineer.
Bob Barrett. I'm on the Historic Zoning Commission and the Housing Authority.
I'm John Shore. I'm the Franklin Transit Authority.
Former.
Somebody used to call me X.
Clyde Barnhill, Alderman at Large.
Greg Caesar, Alderman at Large.
Patrick Baggett, Ward 4 Alderman.
Gary Vogren, Building and Street Standards and Franklin Public Arts Commission.
Doris McMillan, Franklin Transit Authority.
Ann Peterson, Alderman at Large and on the Planning Commission.
Michael Scott, Stormwater Appeals Board.
We got a bunch of staff in the back here. Let's do a quick one for these folks because they're here supporting a lot of the work you all do.
I'm Emily Huffer. I'm the Historic Preservation Planner, and I'm the staff liaison to the Historic Zoning Commission and the Civil War Historic Commission.
Ariella Stanford. I'm in the Planning Department, and I'm the staff liaison for the Board of Zoning Appeals.
Amy Diaz-Barriga, Assistant Director of Planning for Current Development.
I'm Jeff Fleschauer, Board of Zoning Appeals.
Melissa Ryerson, Communications Manager, City of Franklin.
I'm Jessica Davey, Revenue and Licensing Manager and City Court Clerk, and I'm the staff liaison to the Beer Board.
I'm Emily Wright. I'm the Planning Director here at the City.
Kelly Dannenfelser, Assistant Director of Long Range Planning and Historic Preservation.
Jamie Ewald, Organizational Development Manager.
Ahil Rajpuri, Management Fellow.
Me again, Amy Sue Banker, Law Department.
Hi, Sarah Schilling, Assistant Deputy City Recorder, and I also maintain all the membership lists for the Board and Commission.
And I'm Casey Anderson. I'm the Deputy City Recorder, and I work with Civic Clerk.
A lot. Michelle Hatcher, the Director of Water.
Blake Harper, Staff Attorney.
You all saw me earlier, Bill Squires, Assistant City Attorney. This is now a floating microphone. Where am I going?
Can we get everybody? Oh, Nick, you can introduce yourself.
Hi, my name's Nick Mann. Am I supposed to say anything else other than my name? Oh, my Social Security number? Got it. Yeah, I'm a member of the Planning Commission.
Thanks, yeah. We'll go back around with personal information in a little bit. That's really all I had. I'd be glad to take any questions anybody has for me. Again, thank you for the service you're providing to our community. It doesn't happen without the leadership of citizens who step up, and that is greatly, greatly appreciated. One thing I will add, because Sarah made me think of it, one of the things we worked on is a new portal for those that are interested in becoming citizens that serve in our appointed positions for boards and commissions. So it's right on our website. It is evergreen and ever open. Even when we don't have a vacancy, you can still express your interest in serving. So that is there and a great collection point. When we do have vacancies, we're still going to reach out on social media and ask people for their interest. But this is a way to route those, but also just when people are interested or express an interest, it's a great place to point them so that they can step up and help serve and show that interest. So I'm going to hand it over to Angie and talk a little bit about our agenda structure.
Hi there. Sarah's going to come up here, and I'll let her tell you. Okay. So speaking of, I'm Angie Scarp. I am your city recorder, and your two deputies are making their way up here because they're going to help demonstrate what I'm going to talk about. And then Sarah, remind me to let you answer that when we are at the end here. So you may or may not have noticed yet, I don't remember if Planning Commission has had a meeting since we changed this. I think you have. We have the section now on your agendas called Setting the Agenda. This is a section for you to take formal action as a board or commission to change the order of items on your agenda. So you've always have been, and you always still can, as a single member of either a board or commission, remove an item from the consent agenda. So that doesn't change that. You can do it. You do not need to have the whole board's approval. So to be super clear on that, one person can say, I would like this item removed from a consent agenda, and it's removed. So I want to make that part really clear. That does not change that. So there's a couple steps that we go through when we get to that point. Before any motions are made, it would be a great time for you to say, I would like to remove an item from the consent agenda. You say, I would like to remove item 14, and I would like to actually talk about it today and not have it voted on in our consent. So you will have an option for you to have that conversation before any motions are made. Then you have the chance to make a motion to say where you'd like to place that consent agenda item, or if you'd like to move number 5 after number 7 because of, say, somebody's there to speak on it and it makes more sense to get 5 moved down and get 6 moved up, whatever it is. So you're a chance to move some things around. So you'll have a motion on that, and then you'll vote on whether the board as a whole agrees to move 5 below number 7. So the board will agree on that together. We're going to demonstrate this for you. That's why they're up here. They're going to make some motions, and we're going to have a little vote. But so you can take the item off consent agenda as a single board or commission member, but the whole board or commission member agrees on where it goes in the agenda then, and the whole board or commission agrees on if there's any movement of items. And another thing Shauna wanted me to point out too, you can also, as a board or commission, say, number 20, I believe is not a controversial item. Can we please, I'd like to make a motion to move that item to the consent agenda. And if the board agrees as a whole, you're going to vote, you're going to take a second, you're going to vote, and if you all approve that as a whole, that can get moved to the consent agenda as well. Okay? So let's go through a couple examples because that's a lot of theory and concept. Come here, because I'm going to make you talk in the mic. Okay. So, yeah. No, just your simple majority. Okay, so the first item, my first question is, does anybody want to talk about anything, removing anything from the consent agenda and want to talk about it at the meeting?
Yes, I make a motion to... No, sorry, my bad. I'm just excited to be up here. I would just really love to remove possibly item number 17 from the consent agenda because I have a comment that I would like to make.
So, since there's no other discussion on other things, we're ready for a motion.
I make a motion to move item 17 up to after item 4, since they go together similarly. And I would like to make a comment on that once we get to that item.
I second that motion.
Okay. All in favor say aye.
Aye.
All opposed? Okay. No, ma'am, you do not. Okay, are there any other proposed changes to the agenda? No. Okay, you can, I want to point out, you can make multiple motions and go through multiple votes. So you don't have to make amendments to these change motions. Yeah, and that's right, because we didn't talk about that. But that brought up a good point that I want to point out. We had a motion that was out there. Brandy, had another one that she wanted to make. We could have voted on the first one, and actually it's cleaner if we go through and vote on that first one, and then Brandy or whoever goes, okay, so now I would like to make a motion to move number 11 ahead of number 6. And then there'd be a second. I know, right? So then there would be a second, and then you would vote on that. It's cleaner that way because then the board doesn't feel like they have to agree with all of the changes, just to accept the other ones that are attached to it. So if you do your changes individually like that, then your board or commission can vote on all of them as individual. So it's different than a normal agenda item that you're approving, like a resolution or something like that. Yes, ma'am.
Randy moved it ahead. It was an item under old business, and she moved it ahead of the first item on new business, and that was permissible.
Yes, because you're deciding as a whole board or commission to suspend your normal rules. So because you guys are deciding on that together, you can do that. Okay? So it's different than when we as staff set up and we follow the rules that we go by. You as a board can decide to suspend those rules. Okay? Yes, sir. No, so we haven't set the agenda yet in our little play acting here. We've only made a couple changes that we've agreed upon. So, are there any other changes to the agenda? No. So I'm making sure, are there any more changes to the agenda? No. Okay, may I have a motion to set the agenda as changed?
I make a motion to approve the agenda as proposed or as amended.
And I second.
All those in favor? Aye. Opposed? Okay, now your agenda is set.
So, question, just comment. So people who are cheering, like the mayor's cheering our board, other people are, so the question is,
or comment, is if our mayor's cheering our board and other people are cheering other commissions and everything, they have to remember to continuously ask, does anybody want to move any agendas before the final set the agenda happens. So they are responsible for asking multiple times.
Yeah, that's good practice to make sure that your chair is just making sure that they've captured everybody's requests for changes before rolling into the setting the agenda vote.
But just that point of order, if you get to a place where you're like, a whole lot of people just showed up,
And now I want to move this item up. You can still do that. It'll take a 2/3 vote to make that happen. Once you've said it. It's everything. Yeah, everything else you do is a majority vote, but because you're approving the agenda, you have to have a 2/3 vote to change it. Yeah, right. And that's also problematic if you go through the consent discussion at the beginning of the meeting, no one pulls anything off consent. Then when you get to consent, or as the meeting goes on, you're like, you know what, I really want to pull that item, actually. And so then when you get to consent, you're like, I can't actually vote for that more than I think about it. I need to pull it off consent. When you do that, you can pull it off because any one of you can pull it off. That's how it works. But once you do that, it's a 2/3 vote to put it somewhere. Because you've approved the agenda, yes.
Which is extremely rare.
It's extremely rare. But if that were to happen, if you change your mind, just know that that's how that works.
Thank you, Shauna. I understand. The reason why it coordinated to both is because upon my arrival, I became super snoopy and founded an ordinance that says we have to do roll call vote. It's in your charter.
We had a screen instead of or like the new city hall that would change the roll call to an electronic roll call without Ken having to ask everybody their name and how they vote. It doesn't have to be oral. It doesn't. Can we go back in and change that for our charter? You have to ask the state.
That's yes, you do.
Okay, why we get a new city hall? Is that the effect?
So you could do an electronic system that is a green light, red light type thing or whatever on the screen.
That is an option.
Yeah, but you're spending money for that when we should be putting it into this city hall.
We can further than technology.
And the whole thing is, so people can see what you want. So you probably need to have like the screen.
Yep. Exactly. The point is that that the public knows who voted what. That's the point of the roll call vote and the spirit of that. Yes, ma'am. Yes, ma'am. Yes, ma'am. It's cleaner that way. Now, the guys are giving me the dirty look because they really would like to have their time if there's no more questions, although I know that they want to make sure you have all your questions answered. And if you come up with any other questions later, your recorders are sitting in the back there, and you can come see us. We will be here for the extent of your training. And you can also email us at recorder@franklintn.gov. We are available to you all the time. Yes? Okay, good.
And this is only about order. You can't add anything. Remember the 48 hours that Melissa talked about? So this is just about setting the order of what's already on your agenda.
Yeah.
Right. Thank you.
Yeah, right. You can't talk about it. New. I do want to point out in your packet that there is a list of boards and commissions and the attorney assigned to you and then the paralegal assigned to you. Just so you know, so if you have questions, you can reach out to us. And also in your packet, we took what was on the dais, the little sheet about Robert's Rules, and we made it a little bit simpler for you guys. So it's really just kind of includes the things that you always use. And that is also in your packet. I'm going to turn it over to Blake and Bill, and they're going to talk to you about Robert's Rules. And I know you're probably thinking, oh, no, this is boring. It's not. You're going to love it. So hold tight.
You are going to love it. Again, I'm Blake Harper, staff attorney here. This, to my right is the assistant city attorney, Bill Squires, and I'm going to let him start us off.
Thanks. So just a quick show of hands. Who all in here has already had Robert's Rules training with the law department before? So pretty much everyone. All right, so let me start with just some basic facts before I even begin, and I'll tell you what's about to happen. Robert's Rules can be a little dry, can be a little boring, right? It's only loved by nerds. I'll just say that now. I am one of those nerds. I'm not proud. People have been cooler than me all my life. So I do love it. But we do recognize that you've already been through it a little bit, and we want to make it a little more fun than usual. So what we've got is this. This presentation is basics, literally the basics. We're not going to go into the this comes up once every 3 years kind of scenario, gotcha, you didn't know the answer kind of situation. This is going to be hopefully pretty quick. We're just going to go through the basics. After that, we've got a game. We may or may not have created a Jeopardy game based on Robert's Rules. You'll see it in just a minute. We're not going to play it exactly like Jeopardy, and we'll give you some rules about it when we start. That's a little hard, making you ask things with a question and that's too much. So we'll go into that in just a minute, but let's go through this. These are the basics. For your meetings, these are things we talk about a lot. You got to have a quorum. We know that part. It's required to do business. Typically, your bylaws set forth how that works. Sometimes state law kind of defines it, but typically it's in your bylaws. Having said that, your bylaws, as you know, are your separate group of rules and regulations that control the kind of the nuts and bolts of how your meetings operate. So-and-so presenter gets 3 minutes, then after that, so-and-so other presenter comes, then the staff presents. It's that order of business. It describes a lot of the nuts and bolts of your actual meeting. So, as I just said, what's on the PowerPoint? That's your standard order of business. It talks about minutes, unfinished business, new business, all of that kind of stuff. Also about your meeting, here's a quick fun question. What 3 things can you do if you don't have a quorum? That doesn't happen often, but it has come up. There are only 3. You can vote to adjourn, you can take a break, or you can choose the next time you're going to meet. If no quorum, that's all you can do. Everything else is literally null and void. Rare, but it has actually happened in the last year, I'll say that. Yes. Ms. Blanton. Ms. Blanton agrees, and she is giving me the evil eye. So your agenda, as you heard earlier, is controlled a lot by the Open Meetings Act. There's a lot of rules now about how all of that works. You, of course, just talked about how to set your agenda. As you know, it must clearly apprise the public of the matters to be considered. That's the purpose. And then no action on an item if it's not on the agenda. That's the state law has more recently addressed that. There is an exception that kind of floats around in the law about emergency situations. It's really hard to square that with how agendas work now. If that should ever come up, we would address it on a case-by-case basis. But typically right now what the law says is emergency things are really hard to get onto your agenda. It's really not something you can do. The law did say for a long time, it did allow for emergency situations. The recent changes make that a whole lot harder to do.
So how many chairs do we have in this audience? If you raise your hand if you're a chair. Okay, great. So this slide especially applies to you. So the role of the chair, really 4 central roles of a chair. You run an orderly meeting, recognize members, rule on votes. That's something that we don't really do much at the city as far as ruling on votes, but that would be just as Robert's rules in general. And then rules on procedure, which would definitely happen. So running orderly meetings is something that we see a lot. It's the chair's role to handle issues with the public when they come in and decide if they're going too long, speaking too long, or if they are getting unruly, that sort of thing. They recognize the members to speak. And obviously, like I said, ruling on procedure. There's some sort of procedural issue. A lot of times it's in harmony, in conjunction with your legal counsel there, who would be one of the 3 of us. So the most basic rule of Robert's Rules is to proceed by motion. We saw a great little skit of that earlier. The way to do that, as most of you know, is to say, I move to, or I move adoption of. We typically give a recommendation, the staff does here, so you will know what the city is recommending. Keep in mind, if you're going against staff recommendation, you must give a reason for that, why you are going against staff recommendation. That must be on the record. So types of motions, really 3 main types of motions that we see here at the city. Main motion, and then you have your subsidiary motions, which would be an amendment. And then your privileged motions, motion to defer, motion to recess, motion to call the question. So the privileged motions stop everything else. You can only have discussion about those, whatever, with that motion, those privileged motions, and the vote must be had before any other business can take effect. So if you're ready to call the question and go ahead and vote, if someone calls that, everything else has to stop.
So do you always have to have a vote whenever you when they call a question?
Yes.
Because most of the time I don't. I guess maybe I should say it.
Well, I see what you're saying. The vote to call the question would just mean to move on to the main motion. If that's would you agree with that?
Yeah. So, and that actually happened last night. I believe Mr. Baggett Alderman Baggett called the question. What I observed happening is no vote happened, but there also wasn't any real opposition to ending the debate as it was. So technically, should a vote have happened? Yes. Did it appear that the record was damaged in any way? It didn't look that way to me. Certainly Shauna was there. She's nodding. It looked like the body had no real opposition to stopping and going on. Correct, perfect is have a vote. In that scenario, it was kind of no harm, no foul. Does that make sense?
Okay.
And there was a question from Greg Caesar.
But technical perspective in that scenario is the vote that did occur voting on the call to question, or is the vote that did occur voting on the actual motion?
Yes, and I'm going to make eye contact with Shauna to make sure she continues nodding. The way I understood that as it took place is that everybody agreed the call to question didn't require a vote. You're really on the vote you were on. It's just the debate ended. Now let's vote.
And the mayor stated it was about the item.
Yes.
That is, he didn't say it was about the question. He said it was about the item, and then he voted.
Yes. So it was kind of no harm, no foul, but that's the result. You should vote, but in that scenario, it was okay.
Is that a majority? What's the vote?
Majority, 2/3? 2/3 to call the question.
I make a motion.
2/3 vote call to vote in three always question.
The face wasn't yet. Should be clipboard.
I've seen 2 answers. The reason we're pausing is I've seen 2 answers to that question. Shauna, agree? 2/3?
the other sheet. Oh, yeah, but this is condensed too. This is a new one.
Yes.
Yeah. The old one that called question.
Say again?
This is the old version that called the question.
The old version had, and the old version had a whole lot of other things that we took off that we just don't do much of.
So generally speaking, vote on when somebody says call the question, take a vote.
Sure, and the way to think about that is this. There is a sort of perfectly run by way of Robert's rules that keeps it neat and tidy and orderly and all that kind of stuff. That's always the goal. It's often hard to achieve. And in that scenario, the chair heard a call to question happen and it seemed like all of the discussion had ended. So the practical effect was the same. Does that make sense? The problem becomes if you stop following the rules and just always try to just do the practical effect rather than doing what it really requires, you could be wrong from time to time. That's really the issue.
And not only that, but in that situation like last night, what the chair did, thank you. What the chair did was clarify what the vote was about. So restating the motion that was on the floor. The question had been called. The chair said, "We are voting on XYZ." So does that make sense? That's just to clarify with the board of what was happening.
So, okay, let's not talk about last night's meeting.
Sure.
So, what we need is a clear definition of calling the question. Not last night's meeting.
Yeah.
We're in it complete. There's all kinds of discussion. We're going over and over.
It's turning, yes.
Same thing. So I, as a planning commissioner, say, I want to call the question. Okay. This and that, please clarify. That means we stop this discussion that goes on and on, and we vote on the motion that's on the floor.
Yes, correct. And so, no, not what's on the floor. So to clarify, if I can clarify Marcia's question, we're not going to talk about last night's meeting. Let's just go in general. Planning Commission is having a discussion because Marcia's there. It's churning. I mean, it's churning and boiling, and boy, it's going on, and we've been doing this for an hour and a half. Marcia's fed up, and she says, I call the question. What happens next? The debate you were having that went on for so long and churned is now stopped. You are now going to determine whether or not you're ending the debate and calling the question. So that's what Marcia was asking for clarification about. That is the correct answer. That's not debatable. Right. It is debatable to call the question. Yes.
I have a lot in New York State right now, and I'm talking.
Correct.
Yes.
Illegal votes.
Yeah, and to be clear, debate, we haven't really gotten to this in the presentation yet. Debate and discussion is always about the question in front of you that minute. You, Planning Commission, churned for an hour and a half on this other question. Now we've called the question, and the question in front of you is, are we stopping? That's all you talk about. You can't go back and say, I'm still mad about what these builders are doing over here and whatever, and I don't like that. Your only debate and discussion is, should we end this now? Does that make sense?
I say, I thought once the question is called, you vote then. If it gets a second, then you vote on the primary topic of the debate, whatever that.
That's never been done.
You can, I mean, there's nothing wrong if you don't debate it. The question was, can you discuss whether or not you're calling the question? The answer is yes. Right? You don't have to. If nobody has anything to say about it, you just want to vote, you just vote. Does that make sense?
But the question was, once you vote, if you vote to call the question, there's no further discussion on the motion that's in they're talking. You vote on that, right? Yes.
Talk about the underlying.
Yes, that's the rest.
Yeah, literally call the question means that churn debate, that stops. Now you're voting on that. Yes. If the call the question passes and succeeds, it stops the debate on that you were having, and now you vote on that. Does that make sense?
To invite the question.
No.
Calling the questions 2/3.
Oh, I just looked it up. It isn't.
Okay. I was poised to, there are two, just so you all understand, there are two answers to this question, and I've seen both. My gut instinct is always to say majority. We see some things from time to time that say 2/3, but Robert's rules, if we get to the Jeopardy game, you will see is designed to govern small bodies, medium bodies, giant bodies, the United Nations. It literally is supposed to cover everything, right? So there are sometimes two answers to how the votes work depending on the size of your body. And I don't mean your body, the size of your board or commission. Bev.
Robert's Rules of Order says 2/3.
Yeah.
In the book that you're handing out.
Well, so instead of voting Robert's Rules, and it says that it's just a majority.
Well, this book, like everything else, says it's 2/3. So that's why.
The notes on this.
No, but to be clear, what I said remains true. There are two answers to that question.
What's our answer?
Our answer is majority. Majority.
Okay.
Majority. That's not in our charter.
My cows are good. So in fact, it's turns if you choose to follow Robert's Rules of Orders, then have to follow Scott and Tristan.
That's that.
So I would debate that leads to fear. Another question.
I have always a question.
Regardless of how we love it.
Yeah.
One other question is it permissible to interrupt somebody who's talking to say call the question, or do you have to wait till they finish speaking?
A motion to call the question, also in our materials as we move forward, is not an interrupting motion. That's on your sheet, I believe. If we kept the interrupting column, that's not an interrupting motion. And by interrupting, it doesn't mean interrupt debate. It means interrupt the individual speaking. If you were seeing that in the prior handout, that's what interrupting meant. Can I interrupt Bev while she's speaking and say, enough with you, I'm calling the question? That is not an interrupting motion. The only real interrupting things are like point of privilege, point of personal order, those kinds of things.
And do you also have to, when someone finishes speaking, say, Jason finishes speaking, and I say, call the question, do I need to be recognized by the mayor? Like just say, call the question.
When he finishes speaking, yeah. Right. Do you have to have the mayor's recognition? No. 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 Right. I mean, practically speaking, so let's talk about this for a second. Practically speaking, you should always get the chair's recognition of you speaking. In practice, what happens in a live meeting is that before anybody really has, sometimes it goes both ways. I've seen it both ways. Sometimes we'll say, Mr. Mayor, I call the question. And the mayor will say, okay, thanks. If you just say it, the mayor's never bothered. I've never seen him say, oh, you didn't ask my permission to say whatever. So best practice is get the chair's approval. Is it fatal if you don't? No, it's not. Yes. In practice, what really happens is it's more conversational than that.
She's done our press grace. You guys for years, and we're really trying to do this, that you should talk to your chair, not to each other. So when you have a motion, you should always say, Chair, Mayor, I'm most, or Mayor, I'd like to almost always work through your chair. Same thing with historic zoning. You're not talking to each other, you really got to talk to the chair. And that's the highest. He did this over the past, 5 or 6 years to make sure you work through your chair.
In practice, what occasionally happens is you have a lot of discussion. Because remember, calling the question is stopping the debate. It's gone on so long now. Right or wrong, somebody's frustrated or they're at that point where they're kind of done. So what occasionally happens is somebody just says, I call the question. I believe that's how Alderman Baggett did last night. I call the question. Should you address the mayor, get him to recognize? Yes, absolutely. Sean is absolutely correct. Is it fatal if you don't? No. Would we prefer you do? Absolutely yes. Does that answer the question? Okay. Is this still you? This is still you.
Still me.
Okay.
So here's some common motions. We have the motion to adopt, motion to defer to a date certain. Remember that. We'll get to that in a little bit. It has to be to a date certain. Motion to recess and motion to adjourn. Pretty self-explanatory. There you go.
Time.
So if you recess for...
It needs to be clear what you're doing. It needs to be clear what you're doing. I mean, are you asking me, can we just say motion to recess and we'll randomly show back up, or? Yeah. It needs to be clear what you're doing. So if you name the time, I move we recess until 8 o'clock. That's not a time. I move we recess for 10 minutes. All of those things make sense. It tells the people in attendance what's going on, anybody viewing what's going on. Does that make sense? Yes. It is a voting motion. So here's one we always remind you about. This is my chance to say one more time. A motion to put something on the floor for discussion purposes does not exist. Just remember this. If you make a motion, you have to be in support of what you're moving. I move to approve for discussion purposes. That is not a thing. Yes. Anything for discussion purposes, if you are the maker of the motion, that is not a thing. It is not for discussion purposes. You are expected, if you think about it this way, away from just in general, Robert's rules expect whoever makes the motion to advance the argument, right? Because this is about debate. So if you say I move to approve, Robert's rules contemplates that you're going to argue why it should be approved. That's the idea. Now, if you move to approve and you change your mind, you're not precluded from voting against it. The whole point, if we back up for a second, again, is debate. So if you say, I think this should be approved and here's why, debate ensues, right? If during the course of the debate you change your mind, that's perfectly fine. That's literally what debate is about. Does that make sense? Now, the funny thing is, the second actually can be for discussion purposes. The second maker does not have to agree with what the person has said. The second maker is just getting it on the floor. So what happens if a second doesn't happen? It fails. However, if it's voted on without a second, should that happen, it's not fatal, right? Because you had at least one proponent getting it out there, then the debate happened. That's what Robert's Rules says about that. But the key thing to know is if you're making the motion, you're expected to advance the argument. The second person can say, for discussion.
I'm afraid you try to do that. That was really weird for y'all. We should say it.
No. It does. It does. This is just pointing out that that is the rule. If somehow, it's the somehow that y'all didn't follow. If somehow a second doesn't happen and we just jump into debate and then vote, it's not fatal. It's not null and void. The lack of the second didn't kill it just because of that. It's required. Let me say it a different way. If we go to court and somebody says that vote's not valid, Robert's Rules will say, yeah, it really is, because they had the debate. The key was the getting to the debate. Yeah, I will say that's a good point. So John's point is that means you got a weak chair. That's really unusual. It's hard to contemplate how you'd get from a motion into debate. That's a pretty chaotic meeting, right? Right, but let's stop and think for a minute. Millersville, right? What's going on over Millersville? Think about how these rules applied there. That's why some of these things are there, right? You've got the Millersville craziness going on that was really difficult to manage. Then you've got some of the videos we played for you before where a meeting gets really out of control. Imagine, these rules still apply there. So there are some caveats that say you're expected to do these things, but if that fails, it's not the absolute end of the world. That's really all it's saying. Because your chair was paying attention. Because the mayor, your chair, because you, Chair Pierce, were paying attention. Again, that's the very chaotic meeting. I move whatever, and suddenly somebody blurts out and starts talking. And then off it goes. And nobody realizes there wasn't a second. When somebody challenges that vote in court and says they didn't get to that vote legally, Robert's Rule says, listen, they debated that second part, should have been there, it's not fatal, it's okay. Alma. Yes, although you're saying it in a very polite fashion. I think that scenario happens in a much more chaotic fashion than what you've just described. Oh, no, you're good. Any of the chairs I ever see running meetings pay a lot more attention than that. In our meetings, if you started speaking after a motion had died, I'm pretty confident almost every chair I can think of would say that motion has failed, Commissioner McElmore.
Unless the chair is totally opposed to vote against them. So that chair can let it go because he wants it to.
So
agree that the motion is okay and go for second. So it really depends on the attitude and the change.
It does. Okay, so what John's talking about, and I'll repeat it for the recording, what John has just said is, if the chair says, it's all right, Ms. McElmore, keep going. It's all right, Commissioner McElmore, keep going. And that motion is now back on the floor. What he's getting at is this. The chair is the interpreter of the rules as it's going on. Remember Blake's slide about ruling on procedure? That's the chair saying, okay, we let that die for like of a second, but there appears to be more interest. I'm going to put the motion back on the floor. If that goes too far, Chairman Schroer, your lawyer will probably say, I need to interrupt. Can we clarify the record? What's happening here? Let's just be clear. That's the moment when your lawyer, your parliamentarian says, whoa, 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 hold up. We want good, open, honest debate, but this is a little muddy. What are we doing? Do you see what I'm saying? So that point about the second was not meant to be, dwelt on a lot. It's just an interesting fact that if it should go that way, that's how Robert's rules views it. So
The comment that was made about that's a sign of a weak chair that fits in this. A strong chair will apply the rules to keep the meeting going.
Absolutely. 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 And that's why we have these trainings. That's part of it. So once the motion's made and seconded in normal order of business, chair states the question. Sometimes that doesn't happen exactly like that, but often if you're reading the Board or Commission, you know whether or not they understand. If it was a very simple motion to approve, you don't have to reread the whole thing. If, however, it really needs some stating, everyone I've seen does this very well. They restate kind of where we are, especially if you've had a lot of debate and amendments and that kind of stuff. But you state the question again and you go on for debate. Once that happens, the motion's with you. You own it. The motion's before you, belongs to the assembly. The maker of the motion typically has the right to speak first. I don't know that we strictly enforce that. It almost always plays out that way that I see, though. Typically because the maker of the motion is the one who really has something that they're really wanting to talk about it. As we say, speakers should always address the chair. So this is you.
So getting into amendments, when you have your main motion, oftentimes in the heat of the moment, when the debate is getting going back and forth, a lot of times motions are made to amend. And so when you're making a motion to amend, just a reminder, please say exactly where in the main motion you would like the amendment to be made, exactly the wording that you would like. If you want to remove words or add words, we need clarity. It's often easier to vote. So think of it like a ladder, climbing up a ladder, and you have to climb up the ladder with the amendments, and then you vote on that whatever amendment is on the floor before you can come back down and hit that main motion again and vote on the actual question at hand. Does that make sense? So a motion to defer must always be to a date certain. We don't defer any items indefinitely. Here at the city, we typically vote to a date certain. If we want to defer indefinitely, then we vote to deny the item. Also remember that if there is a motion to defer on the floor, there's no discussion until the vote has been made on that item. So no more discussion on that main motion until you vote on the motion to defer. At that point, the discussion is on the deferral? Correct. Yes. Correct. Yeah, you can discuss the deferral. Thank you. But not once you cannot discuss anything else until that deferral motion has been voted on. So decorum, Bill touched a little bit on this. Please remember to wait your turn. It can get chaotic, especially when you're passionate about your point of view. Debate issues, not personalities. That's one of the things that Robert's Rules talks about is sticking to the subject, and like Shauna and Bill and I think all three of us have mentioned, directing your comments to the chair, not to each other. I know that's hard. I know that our tendency is to want to speak to the person that just spoke, but really the orderly way and following Robert's Rules, direct your comments to the chair when you're speaking. Generally, according to Robert's Rules, you're only supposed to speak twice on an item. I don't know that we strictly follow that, but that's the Robert's Rules way.
Let me get the QC. So we just have a last few things, just some general frequently asked questions. Do abstention votes count? They count, but they're a no, right? Really, you're counting positive votes. It just registers you as neither positive nor negative, which is not a positive vote, which is the same thing as a negative vote. See, I told you, only nerds enjoy Robert's rules. So abstention votes count, but they're just a no. So I've said all this probably says the very same thing. Yeah, when that's the case, the effect is a no vote. I should probably put the answer to make sure I say the same thing. Is it true once a quorum has been established at the start of your meeting, it continues to exist no matter who leaves? No, that is not true. A quorum is counted by those present. And we have had situations, the reason this is here, where a quorum was established in a meeting, someone during the meeting says, I have to recuse myself from this because I live nearby, I have an opinion about it, I can't promise I can be biased or unbiased, and they leave. Now the quorum's gone, the item cannot be considered. I've seen it happen at least once since I've been here. Alderman Brown.
Is there a difference, let me see, been asking you about this, between abstain and recuse?
Functionally, no. So Alderman Brown's question is there a difference between abstain and recuse? Abstention is a vote. I'm abstaining from this vote. Like I'm here, I'm hearing the things, I'm not going to vote yes or no. Recuse is I'm out. Does that make sense? Yes. You can call either, but it's, you know. Mm-hmm. So the question is, if you recuse yourself from an item, you have to leave the room. Can you sit there? Can you do whatever? There's not really a rule about this, but what I'll tell you as your lawyer, who has seen lots of crazy challenges, is that you should leave the room. Why? Because everybody in there is probably going to be heated, and if you're there lurking wherever you are in the thing, somebody who gets mad about the way the vote goes is going to say, I saw Alderman Brown give eyes to so-and-so. I saw him nod. You know, you think about your more contentious meetings. Right? So it's just safer. If you're really not going to be involved in the vote, just step out the back door. Nobody can accuse you of anything.
So, piggybacking off of Alderman Brown's comment, if you have to recuse yourself, and that creates a quorum problem, can we still sit there, recuse yourself, and say, I'm recusing myself, just sit there, look down, and not have eye contact or anything, and let them vote? Would that still take place, or is the quorum then null and void?
If you're recusing and the number drops below what's needed for a quorum, they're not voting. It's gone. It is not being considered. Any vote after that is null and void.
But if you're abstaining, you still count towards the quorum.
Abstain counts. Abstain means I'm here, I'm just not going to vote yes or no. Abstain's kind of a weird, I mean, let's just be honest for a minute. Abstain's kind of an odd thing, right? Sometimes it's for a political purpose. I don't want to be said that I vote yes on that, but I don't know that I want to be, they count to me as a no. It's one of those. But it functionally counts as a no vote because it's not yes, if that makes sense. But yes, you were in there.
Reduce the amount of votes. Like,
votes required, none of that changes. You were there. Just like you were going to vote yes or no, you just didn't.
Well, recuse is not the same as a no.
Recuse, you are not involved. It lowers the number of people present. There were 9 people. You walk out, now there are 8.
It's right.
Right. If you flip that number just enough that it goes from 4 to 5 votes, then that can happen. Right?
Sorry, what would be a reason to recuse versus anything that is respect?
That's why I was saying abstain is a little bit of a funny animal, right? Recuse is, and this is the example I saw, I live nearby here. I have an opinion about what they're doing. It's not really unbiased. I do or don't want to do it because I'm a resident near this thing taking place, right? That's recusing. I'm walking out. I'm not participating in this. Abstaining is I'm there. I just don't want to say whether I support this or don't.
A better recusal example might be my wife works for that company.
Any conflict, absolutely. Absolutely. Any conflict is a good recusal.
Because a lot of times you say, I live near there, but I have, you disclose it, but I feel I can absolutely my responsibility.
Absolutely. And that's not, and like as Eric's pointing out, that's not the only reason to recuse. That's just the one I'm thinking of because I saw it. The much easier recusal is I've done work for them. They're paying me to do whatever right this minute. I can't be involved in this, right? That's the very easy one. Abstention is kind of, I know that the words seem similar, like I'm just not going to participate. It's two very different things. Recusal is I'm not participating in this in any way, shape, or form. I'm out. I am out of the room. Abstention is, I'm here, I'm even going to join in the debate. I'm going to say some things pro or con. I'm going to do whatever. I'm going to ask staff some questions. I'm going to do all the things. But when it comes down to time to vote, I'm not going to say yes or no. Does that make sense?
It made you their big chicken.
It can, yeah.
I to use this, you need to man up and vote.
Well, and so.
Athletes use abstain. No, they probably should. First, that is horror.
And so here's the thing.
My team, we say abstain. When we've said, and we counted this, we use abstain when we'd have like a business relationship or something like that. I think we've always used abstain. I very rarely seen us say accuse and then walk out. I know some
I've seen some recusals. I mean, I've seen some recusals, yeah.
Part of this other board is a business with her son's company, engineering company, and she would leave the room. Yes, she would. You would have to go get her, and once or twice I might have forgotten to get her.
So yeah, I hesitate to say, here's the thing, I hesitate to tell you when you should or even suggest or discuss when you should or shouldn't abstain because that's your vote decision, right? That's a political decision for you. You are at that point a member of whatever body, you're choosing how you vote. So I really can't give you strong guidance on that. That's your conscience, you're voting. But that's not the same as recusing.
If it's a conflict, recuse, blackout. If it's, you just don't have the courage that day.
Well, here's, sure, and we're kind of going around the world on some things. So let me kind of bring us back to center for a second. When and whether you recuse, and the evaluation or analysis of a conflict is up to you, right? So I can't always say if you think there's a conflict, you should do a thing. It's going to vary each situation, and what's expected of you is that you think about it, right? Not that you ignore it. It's the ignoring it that is the problem. If you think I've got a bit of a conflict, but you know what, I'm just going to tell the people, here's my little bit of what might look like a conflict, it's not a problem, I can be unbiased. That's perfectly fine, right? But that's your analysis. Commissioner McElmore.
You need to disclose it at the meeting. For example, if I'm on the board of caretaker manage, I'm volunteering. I'm in the Southeast and we have more financial stake in their dogs and habitats building a new development. And when clear commission, now I feel like I should accuse myself. I'm not including, I'm giving to the organization. I'm not
sure.
But the community is standing. So I don't accuse myself, but do I need to state and understand that committee with Oliver or anything at all?
Again, that's your decision, but here's what I would point out to you. The fact that you're even asking the question suggests that you should, right? Because here's the thing, it's not about impropriety. Commissioner McElmore's not doing anything wrong. She's doing great things. What it's about is the appearance of impropriety from somebody who doesn't like the vote that came after. Because what happens then is the people who are mad about the vote say, well, you know, she just worked with her Habitat for Humanity. Of course they were going to vote yes. She's probably told them whatever because, you know, she's with Habitat. You want to avoid all that, right? Don't give them that fuel. If it's something you're thinking about, my advice, my suggestion is always, if it's causing you this much drama in your head, just say it. There is no such thing as too much notice. You can just say, I volunteer for Habitat. I can be unbiased about this. I just want y'all to know. Does that make sense? Ultimately, your decision, though.
Is that staying and just voting present and say?
So present is not a vote. Present is just, I'm here at the roll call. Does that make sense? There are 3 votes. Yes, no, abstain. That's it. Present's not a vote.
But tell you what you're saying very well could affect the whether or not it's a friend.
Absolutely. Yes. Absolutely.
So that's very significant.
Mm-hmm. And you have to think about that. I mean, that is a thing in a live meeting that you're thinking about. And again, there are no perfection type answers when it comes down to an analysis of your connection to a public body, the body you're on, another organization, all of that kind of stuff. What Robert's Rules expects you to do is think about it and follow the framework of analysis and do what you think is right as long as it's not illegal, right? So does Commissioner McElmore have to say that? No. Is it illegal? No. Is it better? Probably, right?
So make sense. And just to add to that, one of the things that our code says is that the standard is when could a reasonable person infer that
that you not recusing yourself could cause a conflict or could cause a potential conflict, and so or could make a person think that it could cause a conflict. So just run through that easier than that when you're considering.
And that's the appearance. Let me add one other thing, and I'll come to Alderman Berger because she's patiently holding her hand. If you have questions about this, you are not on a desert island. You're not in the desert. You're not on an island out in the middle of the ocean. Call us. That's literally what we're here for, is to support you in this kind of thing, right? Alderman Berger.
Yeah, the word I've not heard is, and I think we need to use that, is can you be impartial? So, do you think you can be impartial because your job, people like, my other question went back to these amendments. We were talking about this up here, and when you withdraw, say I make an amendment, and somebody seconds it, and you all talk about the amendment, but then you all decide after the discussion, you want to withdraw the amendment, do you need a vote on that amendment to withdraw it, or do you just need to second?
So there are two ways to do that, and it just depends on how clean you want your record. If the amendment is out there and it's seconded and it's being discussed, you can take a formal vote, and if it lands in the negative, the amendment is not added. The other thing you can do, and I don't encourage it just because it starts to get a little sloppy if you've had a whole lot of discussion, you can withdraw an amendment if your second agrees with it. The second is the linchpin because they've supported it to get it on the floor. If you have a lot of discussion, you're like, you know what, this was kind of a bad idea. Now that we talked about it, I don't want to go forward with that. Typically, and I've seen this happen in meetings, some of you all do this, does the second agree? If the second agrees, then we can pretend it didn't happen. Yes, you're back to the main motion. That being said, what I just described, if you picked up on it, is a little bit messy because you had a whole lot of discussion. The maker of the amendment motion has now changed their mind, which is perfectly fine. But now you're just going to say, you know what, never mind. Like that, a formal vote is actually better to just get rid of it. But you can also do it that way, where the maker says no and the second doesn't object.
Can you say that too? Can you say, well, I was feeling listening to my colleagues that now I see some wisdom here in really not supporting the amendment. So I would ask my colleagues to vote against it. Can you just say that, or just?
I don't know that I would. Well, I mean, remember this is debate, so I don't know that I would ask for people to vote a certain way. I think when you're arguing or debating, you really want to state your position in the goal of convincing other people. I thought this was a good idea when I started, but now listen to everybody talk about it. I don't anymore. I wish I hadn't made that amendment. I thought it was a good idea. Any of that suggests my mind has been changed, I'm going to be voting no, even though I put this out there, right? That's kind of different than will you all join me and hold hands in a no vote? Does that make sense? Greg Caesar, Alderman Caesar.
On to the topic of abstention and maybe the non-spineless way that I see is if I wasn't at last month's meeting, but at the beginning of this month's meeting, we always affirming the minutes from last month's meeting. Now we have YouTube, and so we can go back and watch things, but it's hard for me as a sitting board member to say, yes, this record of that event that I wasn't at is accurate. Then sometimes is abstention, perhaps, for me, I feel like that's the right application of abstention.
Well, yes, and that's another way to think about it. So let's think about that minutes for a minute. When you're voting to approve the minutes, you're not saying, I agree with every vote that was taken there. You're saying this document reflects what took place at that prior meeting. It accurately captured what happened. You could know that because you went back and watched the meeting on YouTube because you're a dedicated public servant, and so you want to know what they say and what they do. If, however, you haven't gotten to that, you could say, I wasn't present for this. I can't confirm. I can't say it's right or wrong. I'm going to abstain. That's perfectly reasonable. I will say, I did not add that word. So let's go on real quick. I promise there's a game to play. So another frequently asked question, can something be defeated by adopting a motion to table it? In some bodies and commissions, yes. In ours, no. So it's not in order here because it suppresses debate. Some bodies, though, if you think of the United Nations, the sort of ginormous bodies, all that kind of stuff, they have a lot more elaborate rules about how this stuff plays out. We don't do it. Here's your law department. We're happy to assist you in any way we can. As I say, please do not feel like you're out lost in the desert, stuck on abandoned on an island with nobody around. Bev, we can send you these if you want. Please call us. If you have questions about this, please call us. Some of these questions, you can go ahead and start changing if you want. Some of these questions I mentioned are kind of for you to decide. And I've had those phone calls, from at least 2 people in this room and from some not in this room saying, here's what's happened. Here's how I'm connected to these people. Should I disclose it? Should I recuse myself from this item, right? And then that's my job to kind of walk you back through the analysis and say, here's how this works. Here's what you need to think about, all of that kind of stuff. So we're going to do, rather than try to do Jeopardy with a whole room full of people, I'm going to ask for 2 volunteers. One is Brandy. Thank you, Brandy. Who's? Well, yes, I did ask. So can I have a second volunteer real quick? All the volunteer is doing is picking questions, just so you know. Anybody else? Would you like me to volunteer somebody? Alderman Caesar, all right. There is nothing to wear. There's nothing to wear. So here's how we're going to do it because Jeopardy would be a little hard with a room full of people. We don't have people set off all that. I'm not Alex Trebek, all of that. What we're going to do is have you alternate picking questions, and then we will see if you get to the right answer as a group. If you have an answer, one of the volunteers being asked about it, please volunteer it and let us know. We'll ask the room, do you agree? And then we'll see if we get it right. The goal is to see, ignore team 1 and team 2. That's when we thought we'd be able to separate the room. We'll see how much money we can make on this board as a group. No. That was the whole idea. So the question was, do you need to be up here? No. That was the whole idea. Since you all are spread out, I don't want everybody to have to get up and move around and all that kind of stuff. So Alderman Blanton, we have definitions and terms, motions, meetings, how to act, and just random facts. Where should we start? Meetings for 300. So who is responsible for keeping the meeting moving in an orderly fashion? Do you have an answer, Alderman Blanton? Okay. Any different answer from the room? The answer is the chair? Is that right? No. Alderman Berger, calm down. Alderman Berger's she's really following the rules. You don't have to answer in the form of a question. We're not going to do that. That's too much. This is trivia, not actual Jeopardy.
Jeopardy form, but trivia.
I know, right? This is why lawyers are not good people. So, do you want to do the next one? Sure.
All right. We have Alderman Caesar. Which one would you like? Go big or go home. True or false? If you have a quorum at the beginning of a meeting, an item can still be considered if someone recuses themselves from that item and the quorum is lost. Are you sure? Final answer. Regis Philbin. False. A quorum is measured by the number of its members present to vote on an item at the time of its consideration.
Alderman Blanton, where are we going? Okay. High rollers. What year was Robert's Rules of Order created? Alderman.
This is the fun column.
Yeah, to be clear, there's no expectation that you know that final column of fun facts. So, any answer? Want to guess? I have an 1894. Anybody else? 1939, 1904.
No, I see some Googlers.
I see people on phones. Okay. Anyone else?
1876.
So here's how this came about. It was an adaptation of the Rules and Practice of the United States Congress, the first edition. Only nerds and lawyers could probably love this. Pocket Manual of Rules of Order for Deliberative Assemblies. Yes, we're doing collective. Alderman Blanton's upset for her team.
All right. Who's next? Alderman Caesar?
Definitions and terms for 100.
All right. Let's see. All right. You guys are sticklers for some points. All right. What was it, Alderman Caesar? All right. The minimum number of members of a body required to be present to make actions taken in that meeting valid? You guys love those Jeopardy rules. It is quorum.
So now we're at 400. We'll just keep a running tally. So now we're at 400. Alderman Blanton, where are we going? What kind of motion is made to postpone consideration of an item to a future day or meeting? What motion is that? Anyone else? Everyone agree? Motion to defer? Yes. Okay. That's correct. So now we were positive 300. Now we're positive 700. All right. Sorry.
All right. Meetings for 100. What is the purpose of using Robert's Rules of Order? I heard quorum, taking order. So the final answer from this area, maintain order in a meeting. Well, the official answer is to provide a framework for groups to facilitate discussion and achieve effective and orderly group decision making. I mean, this was a $100 question, so I think we're safe.
And to be honest, we would have taken a lot of things for that. And that was a very good answer. So, Alderman Blanton, where are we going? Definitions and terms for 500. This person provides the body with unbiased guidance on parliamentary rules and procedures. Who is that? So there are. Okay, hold up. So So the voluntold individual said, me, Bill, or Shauna, just me, right? Just me. So Alderman Berger says parliamentarian. Anything else? Legal counsel. So all of those are correct. So it is technically, under Robert's Rules, you're parliamentarian. Here, it is almost always your lawyer. In some meetings, it's me. In some, it's Shauna. In some, it's Blake. So all of those are correct. You just made more money.
200 for meetings. What controls the order in which a body considers items in its meeting? The agenda. Sounds pretty unanimous. The agenda. Let me add point.
Alderman Blanton, what would you like to talk about? Random facts for 200. Who created Robert's Rules of Order? Okay, so Alderman Blanton. Alderman Berger saying General Roberts. Mr. Roberts. The Roberts family. That's right. Anything else? I hear General Roberts. I hear. Okay, so let's see the answer. It is General Henry M. Roberts, an engineering officer, which is why they are as they are probably, in the Army. Here's what happened. So, but look at the story about how he got there. He was asked to preside over a public meeting in a church and realized he didn't know how to do it. It did not go well. So picture this engineer from the Army in 1876 going up into a church and the meeting doesn't go well, and he thinks, you know what, that's not happening again. I need rules. And there's never been a bad meeting in church. And after that, all church meetings were solved. That's right. So he created the formal collection of rules. That's the Robert's Rules. So we got that one. Oops.
What was it? 400 meetings. What are the two types of business a body usually takes up for consideration? All right, final answer. Old and new business. That's correct.
You guys are sharp. Killing it, yes. Alderman Blanton, where are we going? Motions for 500. True or false? A motion to amend cannot itself be amended.
Whoa.
That's false.
That's false. It's such a good ball.
Because we have short meetings. So I didn't.
That's on the letters. And another section and not itself be amended.
Listen to motions.
I believe that's true.
Okay, so I hear a true, I hear several falses. I'm seeing a lot of false. So I'm going to say the group's answer is false, right or wrong. The answer is false. You can't amend an amended motion or an amendment to a motion. Remember, you go up the ladder and then you come back down. If you've gone up one rung, you can go up another one and go up another one, you just have to come back down. So I give them points for that.
All right. How to act 100. What words would you normally use to start a motion? Yes, I will, after this one. I move. Or motion 2, that's correct. What was the last one? Can y'all help me? This one? Oh, you do? That's true. Technically, that's true. Yeah, that's true. So for those of you that didn't hear, the mayor said he disagrees with this answer. He wants it to be Mr. Mayor or Chairman. I move to. Most honorable chair.
Alderman Blanton, what are we doing? Motions for 300. Let's see what we have. What type of motion seeks to change the language of an item already on the floor for discussion? Everyone agree? That's correct. Motion to amend.
Meetings for 500. Who is permitted to make a motion to reconsider an item that has already been voted upon? Do we agree? He said someone who voted against it. The prevailing side. Do we agree on that one? Okay. Anyone who voted in the majority when the item was considered can make that motion. All right, let me add those points. There you go.
Alderman Blanton? Definitions and terms for 400? A collection of rules adopted by a body chiefly for the government of its members, meetings, and regulation of its affairs. What is that collection of rules? I'm hearing murmurs. Bylaws? Bylaws? That is correct. Those are your bylaws.
All right.
We have made $4,000.
That's right. How to act 200. What would you do to immediately end discussion on an item and take a vote? I heard it. Call the question. All right.
Alderman Blanton? True or false? A body can only have one motion on the floor at a time. I hear a false. I hear a false. It is false. You can have two motions on the floor at the same time. You can only have one question on the floor at a time, right? So think about it this way. You've got a motion to approve. I know Eric's giving me that's a trick question, eyes. So you have a motion to approve. It's second. It's being discussed. In the middle of it, somebody says, I move to defer this. That motion to approve is still on the floor. But now you're stuck on the question, do we defer? A motion to amend is the same way. You still have the main motion and to amend. Even calling the question, right? Whatever motion's out there, call the question is itself a separate thing. You have two items on the floor, but only one question can be addressed at a time. So you could have lots of things, several. Yep. The key there is just a motion is different than the question, if that makes sense. Those can change.
How to act for 400. What do you do if you need to use the restroom or get a glass of water during the meeting? It does happen. Anybody? Ask the chair to excuse you. Do we agree? Ask for a recess. All right, let's see. Point of personal privilege, you can ask for a recess. Express your need to the chair. Just typically, what we see is, could we recess for 10 minutes for a point of personal privilege? Or if you're bold enough, I need to use the restroom, could we take a recess for 10 minutes?
If you're more bold, take the mic with you.
Yes.
So Alderman Blanton, what are we doing? Definitions and terms for 3? Notes that are taken during a meeting. These highlight the key issues discussed, motions proposed and voted on, any other action taken. They are presented at the next meeting for approval. What are those called? Meeting minutes? Okay. Is that right? I know, right? I had to read it in such a way to look at you like, you sure?
Random facts 300. How many times has Robert's Rules of Order been revised? 3. Anybody else? 12. Let's see. 12. I got my Google section coming in strong over here. That with the 12th edition being released in 2020.
We're about to finish it out. Alderman Blanton, where are we going? How to act. How to act right for 300. Let's see. I know. I just added that for some fun. What 3 ways can you commonly vote on an item? We talked a lot about that. Yep. So I heard yes, no, abstain. Everyone agree? Okay. Yes, no, and abstain. You can use aye and nay. If you enjoy being a nerd like me and like to know, you can say aye and nay. You can do that. That's acceptable. As we said, an abstention vote counts as a no. So we got points for that one.
See, make sure you get your points. All right. What motion is used to get an item on the floor for consideration, and what must follow this motion? First and a second. I heard it. Motion to approve or disapprove and a subsequent second. Good job.
It's not like random facts for 100. What actions can a board or commission take if there is no quorum? We talked about that. There are 3. Set another date's 1. Take a break. What was the third one? I heard it over here. Yes, so go ahead. Adjourn, take a break, or set a new time to meet. Anything else you do with no quorums, null and void. Those are the 3 things. I would give them those points, that money.
All right, 2 more. Motions for 200. What is the amount of votes needed for most motions to be passed? Simple majority.
And Alderman Blanton, I think you get the last question. I'd like definitions and terms for 200, please. Ending the meeting formally, disbanding the body until its next meeting. What is that called? My favorite, Mayor. Absolutely. Everyone agree? Adjourn? I'm saying adjourn.
That was so fitting for you.
And it was fitting. So thank you everyone for doing that. We made $6,100 off of our trivia board. You all knew this stuff very well. I'm going to hand it over to Shauna. If you have any questions about anything we talked about today, please don't hesitate to reach out.
So thank you to Bill and Blake. Yes, round of applause. Thank you. All right, a couple of housekeeping issues about lunch. Most lunches, there's 2 people who we're still missing, but almost everyone else's lunch is out there in alphabetical order. So just grab it. There's some drinks also, some ice, and then if you look on this side of the hallway, there's some desserty kind of things if you want to grab that. We're not really going to stop. We have to listen to Michelle in a few minutes about some utility things. So just bring your lunch in here, take a quick break, go to the restroom if you want to. We'll probably start in about 10 minutes.
All right, so I'm going to talk really briefly about elected officials. Who, if you are not an elected official, you don't necessarily have to abide by this. In 2017, the legislature passed a requirement that any personnel that supervises, controls, and operates a governmental utility must abide by continuing education requirements. So there's the TCA code in there. If you in your packet that Amy Sue printed out for you, there's also the TCA code in there that I printed. You can also reference that as well. But what that really is all governing body members must have so many hours of continuing education. We'll go through those. And then you're required to fill out an annual training statement by January 31st of each year, regardless of the number of hours that you have attended. So what those require... So it is, okay. You're jumping ahead, Mayor. Can you not steal my thunder, please? All right, so the requirements, so for new aldermen, within the first year after an election, you must obtain 12 hours of education, right? So those hours are counted the same way that, like my, engineers continuing education, for PDHs. For those incumbent aldermen, you may submit a request if you've already, our election's in October, if you've already gotten those 12 hours in the previous year, you can submit a request to carry those over. But then within those next 3 years of your term, yes, you have to get 12 hours. So a total of 24 hours. So the first year is 12 hours, and the next 3 years are another 12 hours. This is the website. So I copy and pasted it here because I know you have the documentation of the presentation of that. I also don't remember this, so I just Google search Tennessee Comptroller Continuing Education and come up with this site all the time. So there's a little cheat for you. You can also contact, there's the number and the email address. It goes directly to the comptroller. It used to be John Greer, and I can't remember the guy's name now. Yes. He'll respond back. The great news is I have actually submitted this 5 hours of training to meet that 12 hours requirement. We're gonna go on to the next one. So each utility district's commissioner, so you all have to certify that by January 31st. You've met those calendar courses by filling out an annual written statement, outlining those. And then this talks about the failure of not doing that. I know you probably never have, so I'm not really quite sure how strict they are on this, but I'm not an elected official. So the topics for that training, so I copied the official TCA wording in here, board governance, financial oversight, policy-making responsibilities, and other topics reasonably related to the duties of the members of the Board of Commissioners of Utility District. So I have this as being, this annual training we've done for the past couple years. We've submitted that, so this is 5 hours of training. In the past, what I've also done is I have also done tours of our reclamation facility behind Franklin High, of the water plant on Lewisburg Pike. I've also counted the cost of service study that we're about to present to you all. I'll apply for that as well. When we've presented the many discussions of impact fees, we've done those. When I present the budget to Budget and Finance, I'll request it for those aldermen. And then sometimes we have specific development kind of discussions where I kind of look at what we're going to be talking about and see if that kind of is the greater good. And so I'll submit those as well. I've given presentations on compliance history, our municipal code changes that we do, that applies as well. So I try and be really cognizant about what the water department presents to you and getting board credit for that. But I only know what I present to you. So if you guys are not, if you take classes outside of what we do in a work session or through a tour, you'll have to keep track of that, and then you can let me know. So in 2023, this is just an example of the training that we provided that I submitted for board approval. So we did tours of the demonstration facility over in the Red Wing neighborhood. We did a work session presentation on the results of those. If y'all remember that. All of the impact fee ones that we did, we changed installation fees, we presented the budget to Budget and Finance Committee. So I do try and capture those. Those are typically a minimum of an hour. Does anyone have any questions? Okay. All right, so for those topics in the work session, I will submit a request to help you guys kind of out because it's for all of y'all. And I keep track of it. So this is my little Excel spreadsheet that I do. I keep track of everything that we present. And so if you ever have a question about how much you have for the year, you can certainly ask me, you can certainly email me. So I don't keep track of your individual sessions. So the mayor a couple years ago sent me like, I think 12 trainings that you had took on your own. And so I gathered all of them and added them to here. If you want to do that same thing, I would love to keep track of them. Let's see. So let's go to this packet. So the other thing that I copied in here after you get through the code. So this was a presentation from the comptroller, one of the webinars that I sat in that talked about some of those. Ross Kalana is his name. He's the one that typically approves the training, but it has all of their email addresses, and then it's got some so penalties for training non-compliance. So it has in quotes reasonable sanctions. Let's see. And then at the last page is some frequently asked questions that have come from other, like, will internal training be approved? Yes. How is training approved? So it's just this website that I typically go through. We have, there's various, let's see, on here as well. If you do a search for, let's see, going back to this website, if you also log into this website, there is a series of hour-long trainings that webinars that they have put together that you can listen to, and then you'll get this fancy certificate, and you can keep track of it that way also. There's a lot on there about setting rates, about, kind of master plan development and planning for the city, those types of things. Does anyone have any questions? Yes?
Not a question, but a comment. Thank you for tracking that, because I got to tell you, there's no way I have one more space for tracking what I've done and not done. So thank you for tracking that. I didn't know you were, but I love that you are.
Well, and Eric usually does a pretty good job of telling you at the beginning of, like, when we present something at a work session, pay attention because this is for credit. So that kind of captivates the audience a little bit. Yeah.
Just very specific to me, training that I experienced as a Board of Zoning Appeals member, was it eventually relevant, or does it start when you're over to
So the way that, so one of the requirements is that you have to apply for the continuing education prior to the event happening. So that probably wouldn't, but I think in other instances, if there is other, planning commission or other items that could count for that, if you want to, I don't look at all those agendas every day. So if you want to let me know if there's something that there's something appropriate, I can certainly apply for that for you, and for whatever alderman that would apply to. I'm happy to do that. It doesn't take that long I can get with whatever director that is to do that. Let's see, so when I had talked about some of the things that I've done in the past about the plant tours, I would be more than happy to give you, there's some new folks on here who have not had a plant tour probably. I would love to show all of our shiny toys off to you. And we're actually, I think, working with Eric to have a grand opening, a ribbon cutting for our wastewater plant, so that would obviously be a tour then too that I would apply for. But if there's anything specifically you would like to look at, and then for everyone else too, if you'd like to take a tour of the plant, I'd love to show you around. Let's see, this is my email address, and then in the off chance that you can't get a hold of me, this is Brittany, our office manager, and she can certainly help me research some of those questions as well. But is there anything, this is really quick, I wanted to get this on your radar, because I know it's oftentimes in the way back there in your mind with all the other things going on, so just wanted to bring it up to the front. Do you have any questions? Super. So I will say, so what I plan to do, April 11th, I think it is, we present our budget to Budget and Finance. So for those specific board members or for anyone else who would like to come and listen to our budget, I will have that. We'll do credit for that. We do intend on, what is that first, April 9th? Is that the first work session? Yeah, April 9th, we are presenting a cost of service study. I will apply for that for credit as well, and then there will likely be some follow-up subsections of that we will apply for it. So this year might be a good year to have you covered, but other years it's not as heavy on water, so that'll be up to y'all to make up the rest of that. That was it. That's all I've got. So if you have any questions, my email address is in that packet as well. Feel free to reach out. I'd love to answer any questions, or if you want to set up something, that'd be great. Thank you. I am not sure who's next now. And everyone from law has left. Oh, it's Shauna? Okay. Oh, perfect. This is a great segue. Do you want to, you can go to the website here. So there was a little bit of an issue with making it go to this screen. Oh. I'm not quite sure how to do that.
Well, I can just talk you through it. So there's 3 main ways. If you go to 3 main ways to find the application on the website. First, obviously, you can search it in the search bar, Board and Commission application. Board and Commission application, just search it in the search bar. Or you have the, along the tabs on the top, there's government, and under government is your Board of Mayor and Aldermen, and under that is boards and commissions. And on that sub page, there is a link to that application as well. And then also on the sub column, I want to, you can do apply for board and commission vacancy.
Sorry.
No, it's if you hover.
Did I do it wrong?
Yeah, if you hover over
let
it.
me start over. I can't.
So then if you go over to apply for,
There, right there.
it's always open, and we're always accepting applications. Right, so we will hold on to those applications. We'll hold on to those applications so that when there is a vacancy, we'll provide those to the respective staff liaison and the mayor for consideration. Yep, and you can apply for multiple boards at once as well. So please pass this along and encourage citizens to apply. It is new, and we're all really excited about it. Yeah, well, we don't have it posted anywhere, but I am the one that maintains those membership lists. So I can put that somewhere, work on putting that somewhere, or you can just reach out to me.
When we have an opening, we typically post it on social media to ask.
Yep. Cool.
All right, it's my turn. I do want to say the Robert's Rules conversation was kind of confusing, but we have adopted Robert's Rules. There are a couple of times when we have made a couple changes, like that you can't consider an item at a future meeting, it has to be at the same meeting. But we have also kind of adopted this book. So when you start looking for sources for Robert's Rules, you're going to find all kinds. There are all kinds of websites and different ideas of what requires a 2/3 vote, what requires a majority vote. Whatever this book says is what we're going to go by. So when it talks about whether or not a motion to close debate, how do you pass it? It is a 2/3 majority. We are deciding that today. 2/3 majority. This book says that. So follow this book. If you're in doubt, look at this book. You can Google it. You're going to get a lot of different weird answers because, again, Robert's Rules is meant for really big, maybe even international organizations, but this is kind of what we follow. Let me get set up really quick. Okay, I get to present about ethics. It's been a crazy year or so with ethics with our board. Probably, I'm going to just say unprecedented. Hopefully, we won't ever have to have anything like that happen again. But for all of you, in your packet, you will find copies of the ethics ordinance and a copy of the section on the Ethics Commission. We're going to talk about that, both of those groups in a second. But you just need to keep that handy. It would be really beneficial for everyone to keep that handy. All right, so there are some good examples, and then some bad examples, and then some good examples, and I thought that was really funny. So we're going to cover three things in the ethics portion. One, the ethics ordinance and the ethics commission, the state law, and then ouster. So the ethics ordinance is, again, in your packet. It's found at Franklin Municipal Code Title I, Chapter 8. It applies to all full-time and part-time elected and appointed officials. So that's every single one of you. Also, it applies to the city employees, but we are treated differently in the sense that the ethics ordinance is adopted as part of our HR manual. So when employees violate the ethics ordinance, then it's more of an employment matter and not subject to the ethics commission. So if there's an issue, if you did something, someone files a complaint, we now know how that works. You file a complaint with the recorder's office, and then the recorder's office sends it to me, and then I send it to the ethics commission. That's kind of how that works. If and when it goes through the ethics commission hearing, the ethics commission and courts will look at the reasonable person standard. So what does that mean? That means, what would a reasonable person do in the same situation? Not what you would do and what you did, but what a reasonable person would do. There's some language in cases that say it's the ordinary person who exercises care while avoiding extremes of boldness and carefulness. So if you are a normally bold or careless person, they're not going to look at you. They're going to look at what would a normal, average person do in that situation. Also, a hypothetical person whose character and care conduct under any common set of facts is decided through reasoning of good practice or policy. So that's how your actions are going to be viewed. So the requirements of the ethics ordinance are, if you have personal interests, you have to disclose them. A personal interest, and we'll get to that in a few minutes, doesn't matter if you have a conflict of interest. It's, do you have a personal interest in something right now, whether or not it's coming before you as an elected or official or appointed body. You have to avoid conflicts of interest, and we'll talk about that. You are prohibited from accepting gifts. I know in the video we watched it said $25 limit, but that's not a city standard. The city standard is really $0. And so thinking through how to handle gifts, and we'll talk about that again. You aren't allowed to use the information you obtain from working for or working with the city personally. So if you have heard through the grapevine, maybe, that a business is opening its headquarters here in Franklin, no one really knows. Maybe it's even still under a code word. You're not allowed to take that information and go buy stock. You're not allowed to take that information and try to use it in a way to make money, like maybe call somebody and see if a family member can get hired by this company. So really think about that. You're also not allowed to use municipal time and facilities for personal use or personal gain. That also is very important when you're thinking about running for election. You're not allowed to come in and use city equipment to conduct your campaign. You're also not allowed to use your position. If you are having a situation, maybe you want something, you can't say, well, don't you know who I am? Or to get out of something, to say, don't you know who I am? I mean, you're not allowed to do that either. And there are some outside employments that are prohibited if you are an elected or appointed official. So personal interest defined. This can be complicated. A personal interest means any financial ownership or employment interest in the subject of a vote. And maybe it's a possibility of a subject of a vote. And for employees, if you as a board vote in a company to do business with the city, we now may have a personal conflict because our family member works there. Maybe the city has decided we're going to hire a new bank and we have a family member who's a banker at that bank. We would need to disclose that. It doesn't mean we have a conflict, but we have a personal interest. Also, any financial ownership or employment interest in a matter to be regulated or supervised, and that's kind of similar to what I was talking to you about. Any such financial ownership or employment interest of the official or employee's immediate family, and then immediate family is defined as, and it means a lot of people, parents, step-parents, grandparents, siblings, children, stepchildren, or spouses of any of those people. So you got to really think about all of the people in your family, what they do and what they work for, and whether or not there's any sort of personal interest between you and them and the business you're doing with the city. So if you have a personal interest, maybe you find out that you have a family member who is hired onto a company that the city does business with. It's not a conflict of interest because you're not voting on it, but it already has happened, or maybe you are newly elected and that's happened. You need to disclose that if you can at some point in the minutes, if it ever comes up. If it doesn't, you will need to fill out the form, which we'll talk about in a second. Again, you may recuse if there's only a personal interest. That's not the same as conflict of interest. If there's a personal interest, may, conflict, yes. So here's what the city has drafted, but we pretty much copied this from MTAS. It's our personal interest and gift disclosure form. If you have a family member who is working for a company that does business with the city, you would fill this out. And that's an ongoing relationship. It's a personal interest, but it's not something you're voting on. It's just something that's happening. The gifts is on here too, and we'll talk about that in a second, but do pay attention to what this gift section looks like. So now, what is a conflict of interest? That's any proceeding, application, vote, request for ruling, claim, controversy, contract, or any other matter involving an immediate family member or a matter in which you have a financial interest, fiduciary interest, corporate interest, or employment interest. So now you already have a personal interest in either you or your family members, and now you're being asked to vote on something. Now that's the conflict. Now you've got a personal interest, you have a situation where the city needs you to do something, and you have a conflict. Does that make sense? You guys following that? Okay. So what do? Pursuant to the city's ethics ordinance, you cannot participate and you cannot vote, and you have to disclose. So when we're talking about abstention versus recusal, this is the recusal time. If you are, if maybe in your work time, like your 8 to 5 time, you work for a business that has something before the board, you need to recuse yourself on the record and walk out of the room. This kind of gets a little tricky about what is personal interest and whether you have that. So one question was from Alma earlier about being on, like volunteering for something. We all do that. I mean, everybody in this room probably volunteers for something or attends a church. And those have been tricky in the past, but if you don't actually have a personal interest in that, you just you do something with that entity, but it's not a personal interest. There's no financial gain for you being connected to that. However, if you were maybe on their board and you were getting some sort of benefit from that, or if you worked for them, then that is truly a conflict, and that's when you would need to recuse yourself. Any questions about that, or anything that you guys think, wow, that's weird, let's talk about that?
Well, so Alma asked kind of a similar question before, and I agree, like you're on a nonprofit board, and you're not receiving any financial interest from that board.
Well, if you're on a nonprofit board, if we go back, it says fiduciary interest. Right. And if you're on a nonprofit, you have to make sure that nonprofit is financially sound. That is your responsibility as a board member on a nonprofit. So that is a fiduciary interest to that nonprofit.
So to the question before, I think a lot of folks probably serve on nonprofit boards. I think
Right. So you.
it's not a personal interest.
It would be a personal interest and a conflict of interest, right? If you, but like I'm not on One Genoway's board, but I volunteer for One Genoway. That's different. If I were on their board, I would have a fiduciary interest in and making sure that that company is and that nonprofit is financially sound. So I would probably make decisions, or someone could argue that I'm making decisions to benefit them financially. I mean, it's your choice on what you do, but if you came to talk to me, I would say you should probably recuse yourself as a board member of BOMA. Yeah. Right. And we've had situations similar where a lot of our board went to the same church and they came in for, development plans and that kind of thing. You're not working for them. You just go to the church. No one's asking you to sit on a board and make decisions for that church or any parts of that church. Yeah. Right. It depends on your connection. Josh? I would not do that. I would say you need to put it on the record. It needs to be clearly on the record. If anyone ever were to later comment or ask, like, what happened with that, you just left the room. You didn't recuse. You didn't declare. You didn't disclose. You just walked out of the room without putting anything on the record. Any other comments? I would say I have a conflict of interest and I'm recusing myself on this. You don't have to say what it is. The fact that you're leaving is enough to say, I don't want to be connected to this. But there is a lot of case law about simply being in the room is influence. It can influence the people on the board. Yeah. Any other thoughts? We are all very connected to a lot of things in our city. So if you have questions or concerns, as always, come see me before the meeting and we can talk about it.
Have you ever been faced with a decision where your personal financial interests seem to be in conflict with your government work? Where what seems good for you may not be good for your agency? It happens to a lot of us, and it can be very stressful as we struggle with making the best decision. Imagine that a vendor doing business with USDA has offered your family tickets to a concert headlined by the latest teenage sensation. Do you take the tickets and make your 13-year-old daughter happy, but potentially feel obligated to the vendor for future purchases? Or do you refuse the tickets but then face an evening of teenage tears when you get home from work? It can feel like you are caught between a rock and a hard place. The good news is that by the end of this Ethics Illustrated video, you'll have the tools to confidently make the best choice in these situations. You'll make the right choices for both yourself and for your agency, avoid potential investigation and disciplinary action, and feel a whole lot better in the process. The first step to avoiding conflicts of interest is to be able to identify one. A conflict of interest can occur anytime we have a financial interest or some other interest, such as an outside job or business, that could in some way impair our fairness and impartiality on the job. Some examples of a conflict of interest include outside activities like a second job, serving on an outside board where your official duties are in conflict with your work responsibilities, or owning stock in a vendor. Also, accepting a valuable gift, such as the concert tickets, from a vendor that does business with the government can create real conflicts of interest. Because the next time you give more work to that vendor, you may have created the appearance that you provided that work in exchange for the valuable gift, something that appears unethical to others, violates ethics rules, and damages your reputation. Also, since you feel obligated to the vendor, you may not make the best decision for the government. So by now, you should have the information you need to identify a conflict. Let's say your brother-in-law is a computer vendor, and he approaches you about helping him gain a contract with your agency. Since you have a personal relationship with your brother-in-law, that clearly implicates another set of ethics rules, the impartiality rules. And so you must disclose this to your supervisor or the USDA Office of Ethics. Government agencies like the Department of Agriculture have resources to help you identify and disclose potential conflicts, such as financial disclosure forms, or laws, regulations, and policies that specify that we need to go to either our supervisors or the USDA Office of Ethics with that information. The important point is, if we have identified a potential conflict of interest, we need to reveal it immediately. Once we've disclosed the conflict to our agency, we need to immediately recuse ourselves from any further business dealings related to that conflict. What that means is that, although your brother-in-law is free to pursue a contract with your agency, you must immediately remove yourself from participating in any aspect of that procurement or the selection process. You can't have any part in recommending or deciding whether to give your brother-in-law the work or in writing his contract. In summary, avoiding conflicts of interest means that you need to identify the conflict, you need to immediately disclose the conflict, and you need to immediately recuse yourself from any possible business dealings related to that conflict. 3 simple steps to confidently making the best decision. In the situation involving the concert tickets, it's now probably pretty clear that you have to refuse the tickets. In the short term, it may not make the vendor or your daughter happy, but in the long run, you'll avoid the consequences of violating the federal ethics rules, and your reputation for ethical business dealings will remain intact among your colleagues. And you'll be doing your part to support USDA's strategic goal of working with integrity for American taxpayers. Now, doesn't that make you feel better already? If you have any questions about conflicts of interest, gifts, impartiality issues, or other ethics issues, please contact the USDA Office of Ethics. To learn more about the federal ethics rules, please download the USDA Ethics mobile app for free on any smartphone device by searching USDA Ethics. We're the Office of Ethics, and we're here to help.
There we go. All right, one of the things that we see a lot, I would say even with staff, and it was shown in the video that I showed at the beginning, is gifts, gratuity, honoraria, and that kind of thing. Sometimes people are so happy that they have a project that was approved or something happened and they were happy about it. Even last night when we all got cookies, I immediately thought, okay, we maybe should send some, say something about this. And I know we didn't do anything for them. We didn't actually approve anything, but it just kind of showed they handed out cookies at the meeting, which I thought was really kind of ironic given what we're doing today. I think a lot of people did, which was good. So a public official or immediate family member of you may not solicit or accept, directly or indirectly, a gift from an employer of a lobbyist. So that's kind of important. And a lobbyist can mean a couple of different things, not just people who are lobbying at the state, but from someone, maybe even a consultant or something like that, that's trying to get you to do something. And that is regardless of past friendships. So really kind of think about that. It's a violation of the ethics code to solicit, receive benefit from, accept, or agree to accept any gift, honoraria, loan, favor, promise, or anything of value for yourselves or your immediate family members. And it's a further violation if that gift influences or seems like it might influence you or your work as an official or as an employee. I know at Christmas time we get a lot of baskets. And the way we've handled that in the past is take the basket and put it in an open space for other people to share. Sometimes we've seen things that we can't really give back. Maybe it's you know, I don't know, like a bottle of something. If you can donate it, like what you talked about earlier. A lot of times we take it to shelters, that kind of thing. If it's something that you can give back, and especially if it's something of great value, you should just give it back if at all possible. No matter what, you're supposed to fill out the form that says you got it and what you did with it. And that's really, really important. We have had media requests for our disclosure forms before in the past, and there aren't that many, which is interesting to me. And I think it was probably interesting to the media person who said, well, where are the rest of them? Well, they're not here because this is all that's ever been filled out. If you can't give it back, and if you can't give it away, then you need to give the person this value, the money value, in exchange. So if someone gives you, I don't know, maybe accidentally someone gives you tickets to an event and you go, and then you're like, oh, I probably shouldn't have done that. I've gone to this concert, probably shouldn't have done that. Then you need to reach out to them and say, I need to pay you back the value of those tickets. If you can't do that, and if they won't accept that, then you should take a similar value and donate it and put in the form that you did that. That's really the kind of the way to clear up any sort of gift giving situations. Does that make sense?
So Shauna, if we get like a fruit basket and we put it out for everybody to have, should we have done a form for the fruit basket?
Technically, yes.
And say we put it out for everybody to share?
Yes, technically, yes. All gifts are supposed to be disclosed. Yes.
Somebody could go out and have a meeting with 3 or 4 people, and somebody picks up the tab, and their meeting was about faith-based organization in a church or something. It's nothing to do with the city, but that person who picked up the tab actually does business for the city. And I was the only city person there, but I wasn't there in the city capacity at all.
Yeah. In a situation like that, I would have you really should pay for your own, or try to pay for your own. If they come before the city, or there's a chance that they might, you should, in any sort of near future, you should. Yeah, it is. You're right. It is the perception of that. And again, it's not about what you're doing. It's the people that are watching you and what they might have to say about it after. Yeah, we know, I mean, there was that one time when that happened, and it was a much ado about nothing, but a complaint can be filed and it has to be investigated, and it's a pain to have to go through. People see you out, they see you at restaurants, and if they're wondering, like, what are they doing? Are they violating the Open Meetings Act? Are they taking money that they shouldn't be? Who paid for that meal? If a complaint's filed, we have to investigate it. And that's just kind of the way it is. And the one time we had a complaint that was kind of, not based in much, we did have to investigate it. We had to call the restaurant. We had to interview the wait staff and find out what was being discussed. And it was, not that great of a situation. But again, I know Bev's over there whispering. You can probably tell the story just as well as I can. It was not great. So again, people are watching you. And I feel like right now they're watching you even closer than they ever have before. So really be thinking about what you accept, how you're perceived in public. People are always looking at what you're doing. They know you, and they're watching. All right. So here's a couple exceptions. If you work for a company, obviously you can accept anything that you get from your company. Clothing, gifts, that kind of thing. If you are a candidate and your PAC or somebody gives you gifts, obviously you can accept that. Anything that would ordinarily or customarily be given to people in a normal situation, you can accept that. So if you're at church and everybody's getting some sort of basket at Christmas, obviously you can accept that. Even if the church is coming before us for some sort of development plan. If they're giving it to everyone, you can accept it. If you're at an event and they give you informational material, you can accept that. If you're at an event and they say, take your gift or your business card, put it in a fishbowl, and we'll draw at the end, you can accept whatever gift you might get from that. So personal gifts, so long as they're for a non-business purpose and motivated by a close personal friendship or relationship. I've had several of you come talk to me about this particular exception and whether or not a long-time relationship you've had with someone who might also be in a business that might do business with the city. Like, can you accept that annual Christmas gift? And can you do the annual Christmas exchange? And that's something you've got to really think about and talk through. Obviously, sample merchandise, you're welcome to take that. Any honors or awards that you may be given as part of your participation here at the city, you can keep that. And prizes or discounts if they're available to the general public. And you see that a lot at conferences where, they'll have cheaper things that you can buy. If it's open to the general public, you're allowed to take it. If you're going to speak at a conference on behalf of the city as your position, it would be great if the city paid for that. Don't let the person putting on the event pay for that. Just let us do it. It's just cleaner that way. And that's the same thing for speaker expenses. If you are part of an organization and they do pay for you to speak, it is an exception, but if there's some way we can do it, we would probably prefer to do that. So really important, you must report within 7 days the form gift disclosure if you have been given a gift that is either from someone we're doing business with, might do business with, have done business with in the past. So what happens if you make a mistake? There's the safe harbor rule. Again, fill out the disclosure. Try to get that done in 7 days if possible. Again, if not, return it within 10 days if you can. Pay for the gift. And if you do all of those things, then there's no violation. Does that make sense? I know sometimes people don't realize who's paid for something. So you get invited to something and you get there and you're like, oh no, I didn't realize that it was a developer who's paid for this event, and now I need to do something about it. And I know several of you have had that situation happen to you. So when you're thinking about gifts or conflicts or personal interests, the question's really to think about, and it's kind of like, I'm in Rotary, so we have like the Rotary motto, it's kind of the same thing. Will it affect my decision making? Will it look like it's affecting my decision making? Will I be unbiased if I take it or if I do it? And will it compromise my position in the eyes of others? Any questions about that? All right, so the Ethics Commission. We have an Ethics Commission. Their section is set out in Municipal Code Title II, Chapter 3. It's created by and appointed by our board. There are some very strict rules about them. They have to reside in the city, not be an employee of the city, can't be an elected or an appointed official already, either in the city or the U.S. government. They are authorized to establish their own procedures, rules, and regulations, and they have done that. They do have bylaws that are available to you. You might want to look through those and see how they would run their meeting. They can receive and hear complaints that would be usually filed by a citizen to the recorder's office, and that's me. They are charged with investigating if they want to. They may hire an investigator, or they can investigate themselves. They can make proposals and recommendations to the board regarding the ethics code or any changes they see fit to the ethics code. They review ethics reports, and they can provide advisory opinions when requested. The state has its own ethics commission. I know this is really small, but you guys have it in your section there. This kind of talks about what they do as an ethics commission. But what I think is really important about the Ethics Commission is they provide guidance and interpretations, and I've given you 3 links. One is to their website, and then to their advisory opinions, and then they have really great FAQs for officials and candidates. I think that's really worth reading and looking at. But as you guys know, you do have to annually fill out the Statement of Interest form, We try to remind our board, mayor, and aldermen every year to do this. It's required of every elected official and members of the planning commissions. It's due by January 31 of every year. And if you need a quick link, you can find it here at this link. And if something happens, I can help you work through any issues that have happened. I know in the past we've had situations, you do report it electronically, but we have situations where sometimes their electronic system doesn't work very well, and we have to handle that. And so if that happens, you can talk to me and we can work it out and get it worked out. Any questions about ethics or the Ethics Commission? Any worries that you have? So myself and Bill and Blake, we try to make ourselves available to you before meetings. So if you're looking through an agenda and you don't really know what to do, give us a call or stop by and we can talk through any issues that you might have. All right. All right, I have the next one as well. Do you guys need a break before I start this last one? Does anybody need to go to the restroom? Because we're almost done. Okay, good. All right. So we're going to talk about social media and the First Amendment, and I do have some First Amendment auditors things at the end of this. I was asked to look at social media topics probably about 2 weeks ago, but funny enough, as soon as I started researching it, there was a Supreme Court case that came out that changed everything I was going to tell you. So now I really only have one slide because at this point, the landscape is different, totally different, and we have no new cases to build upon this Supreme Court case yet. So this is, please don't mess up. Please don't let us be the people that are creating case law. That's never good. So government officials use social media to communicate policy, advocate positions, introduce new legislation, and various other functions. When government officials create a designated public forum on those social media platforms, First Amendment controversies arise, particularly when government officials attempt to shut down or silence opposing viewpoints. So I'm not going to ask you to raise your hand, but just think about it. How many of you have a social media account that is just yours? Just you, just your family, just your friends? And then how many of you have a social media account that is for your public persona, either as an elected or appointed official? Just think about that. Because that's the point of this case. This case was decided on March 15th. Mr. Lidke is a resident of Port Huron, Michigan, and apparently was kind of a bother. He was that person that you see at city meetings that's constantly like bothering elected officials and appointed officials, always has something to say, but the city manager friended him on Facebook. Because this person just kept peppering the city administrator or city manager about things, the city manager blocked him. He was like, I'm done with this, I'm going to block this person. It was on a personal page. It was the city manager's personal page. The city manager did not have another page. They just had their own personal page. So the court said, a post that expressly invokes state authority to make an announcement not available elsewhere is official, and members of the public are entitled to make comments in response. But a post that merely repeats or shares otherwise available information is more likely personal, and the owner of the page may well be able to block critical or unwelcome comments. So this is the new test that just came out. So there's some cases that are already in the pipeline where officials have been sued for blocking someone or removing comments. And there was a case that actually was heard like that day or the next day. It was very similar. And the Supreme Court says, we've decided this already. We've given you a test. Take it back to your trial court and and just see how this works out. And then if you have to appeal again, fine. This case was also sent back to have this test applied to the facts. It is very fact specific. So the court says when they're evaluating an ambiguous page like Freed's, it's a fact specific undertaking in which post content is the most important consideration. So if you use your Facebook page and take posts from the City of Franklin's Facebook page and you just share them, like we're having Main Street Festival, City of Franklin posts that, you just share it or retweet it or whatever, that's fine. If you are making your own content, if you're saying, hey everybody, guess what, City of Franklin's having a public hearing on Tuesday about this thing, you are now opening up your personal page to be an official page. So think about how you use it. If you like to do that, if you're an official and you want to do that, if you want to elicit comment and you want to be able to say, I do not support this thing and I want you guys to come out for that, you need to have 2 separate pages. And that's kind of the takeaway. He had his own personal page. No, he would take comments from the city's Facebook page and share them. So whenever they had a post like, congratulations to the streets department for winning an award, he would repost that. Well, the court didn't say that. The court said, we need more facts. We want you to take it back down to the trial court and find out. And let's just figure out. Well, his argument right now was that he wasn't creating new content. We don't know enough yet to know. It's very fact specific, so they may have to do some additional discovery when they get down to the trial court level. Matt?
By the way, a little marketing pro tip for you elected officials. You want to always originate that from your elected official account anyway, because the algorithms will love that more. So if you're trying to tie something you're doing in official capacity, from a marketing perspective, you always want to originate that content on that account and then share it. If you feel like you want your friends to know that you're also doing something, sharing it in your personal page. That's just good. That's just good practice social media anyway, and it also keeps you out of trouble.
There you go. There you go. So, again, this case just came out. It has not been applied to any actual case or set of facts yet. I would just say, if you have a personal page, think about creating a public page. If you have a public page and you don't have a personal page, I would suggest maybe having also a personal page. Because if you want to post pictures of your family and your friends and your vacations, do you really want that on your public page? Do you want to turn your public page or your private page into a public page? Just kind of think about that and how you use it. It appears that resharing probably wouldn't rise to the level of turning it into a public forum. But if you are creating the content, then it might. Yeah. Well, and the court said we're going to also look at your other posts, because in the case they talked about how this particular city manager mostly posted about his family and his vacations. So when you really kind of just scroll through his page, it wasn't even that city related. He would post things and retweet things from the city, but he didn't, most of it was more about sharing photos of family. It depends on what you've done to your page. So there are some cities who are information only. Like their Facebook pages are not creating a forum. They don't want discussion. And they actually turn off all comment. And some elected officials have done the same, where they post out information, but you can't comment on it. If that's the kind of page you've created, then that's okay. But if you open your page up to comments, you just got to let it happen. Yeah, and there are certain things Yeah, and if you're going to do it, I would really have someone help you think through it. The city also has a similar algorithm, but like we don't allow people to attempt to sell items on our page. Like you can't, if we post out an informational comment or tweet, you can't go on there and say, "Oh, hey guys, I'm selling magazines or whatever." You can't do that. That won't even stay. And there are some like sexual content. Obviously, we won't allow. Any sort of nudity, that kind of thing. But if you're going to set rules, it has to be very clear what your rules are. And at least for the city, our policy is we don't delete them. We just hide them. They're still there. They're just not seen for the public. We can see them. Melissa can see them. Eric can see them, but we don't share them to the public. I mean, it really depends on what they're saying and what the post is about. If they're upset with you and they're like saying things about you, you kind of have to let it sit there. Or another alderman. You've just got to have to let it sit there. Even if they say really bad things about you, you just kind of have to let it sit there. But if it depends on what they're saying. I mean, there are some things that, at least for the city, our page is public for like everyone, children included. We have to be really careful about not showing certain types of comments, especially like pornographic and that kind of thing. That sounds okay. I mean, all you're doing is reposting it and telling people time and place. Where are you posting it? Oh, you mean like in the pay, like you're mailing it? Oh yeah, no, that's totally fine. Yeah, no, that's totally fine. This is more about people who comment on the post and whether or not you can delete them. Yeah, so that's totally fine. That's totally fine. It's whether or not you are deleting people or blocking people based on comments. Yeah, on your social media. Yeah. So maybe just go home and look at your page. If you want to talk about it, we can. Again, this just came out like 12 days ago, so we're all kind of trying to figure out what it means and how we're going to apply it to you guys, but really, really think about it. And if you never block people, you don't have to worry about it. It's only about that moment when you're like, you know what, this person's driving me nuts, and I want to delete them, I want to block them. That's when you really need to be thinking about, can I do that? Can I legally do that? All right, almost done. I'm hearing that about some people, yeah. Yeah. Yep. But you know, no one really does garage sales anymore. They just sell it through their marketplace. That's how everybody buys and sells stuff now too. It's just it's an interesting use of technology. So I think a lot of people, and finding babysitters, that's kind of where you have to be if you're going to try to find one. Okay, so last thing, First Amendment auditors. How many of you guys have heard about First Amendment auditors or seen them or had any interactions with them? Okay. That couple of you. Good. So this is going to be new. So First Amendment auditors are self-identified individuals who believe that they are conducting audits on the city and on city government. They like to video. They like to audio tape you. They like to take pictures. They come to all different facilities. They really like police departments, But we're seeing them a lot more now at city halls. They say that they're there to exercise their First Amendment rights. What we're seeing a lot is they make staff pretty uncomfortable. And as we saw these come across the state, we have really been hard training our staff on how to handle these First Amendment auditors, what to say to them, what not to say to them. If you go home and you get on YouTube and you Google First Amendment auditors, there are going to be so many videos. And you're going to find videos of cities doing it great and cities doing it very, very bad. And I'm going to show you 2 examples in a few minutes. There's one in particular, I didn't include it in this, but it was Bristol, Virginia and Bristol, Tennessee. A First Amendment auditor hit both of them. And Bristol, Tennessee rocked it. Bristol, Virginia did not do so hot. The whole point is for them to really upset you and get you to say something or do something that's going to be super interesting to people to watch on YouTube, because they want to get those ratings. Most of them have channels, and they make a lot of money doing this. So just a couple of do's and don'ts. Again, they are allowed in public spaces. So we have thought as a city, what is a public space, and are we okay with people in that space filming our staff? You guys are appointed elected officials, so really your space is probably your seat in the room that you're in, so you don't have as much openness as staff do, but we really do think about that. And also, as you're walking through City Hall, if there's a badge that you have to get in, you have to use a badge to get through there, that is what we deem not public space. So don't let people walk with you back there unless you know them and they've been invited. Really, really think about that and keep it secure. If someone walks up to you before a meeting, after a meeting, or even at the grocery store, if they know you because you're an elected official or appointed official, they know you, and they walk up to you and they're filming you, remain calm. Don't say act as if they're not videotaping you. Just remain calm, remain professional, answer the questions that they have for you. Try to keep your composure. Also, try to be very short and limited. Just say what you need to say. Don't be rude and kind of walk off, but just be like, is that all? Thank you, and just kind of walk off. Don't tell them that they cannot film you if it's in a city building, because they can. If it's in between meetings or after a meeting, they walk up to you with their camera and they're filming you, they have a right to do that. Don't touch them. Do not try to remove their camera. That is assault, and it'll be a whole new video. But it'll be body cam, and then the media will go on it. So it'll be a whole new thing. Don't argue with them, and don't use profanity. Again, it plays out really poorly on YouTube if you do that. And don't threaten them. Yep.
Before you move forward on that one, I would also say you were talking video, but the same holds true if somebody takes their mic and just their phone and put it like this,
Yeah.
and are recording it with it.
Right.
That's happened to me actually at an open meeting.
Yeah.
Over one of the HOAs.
Right. So also think about that. If it's a public meeting put on by planning at an event or space, not the cities, we've kind of turned it into a space that is free for someone to record. Yeah, so definitely think about that. One of the things we see, we haven't seen it at our police headquarters, but we've seen it across the state, where these First Amendment auditors will go through garages and they will try to film the inside of people's cars, city employee cars, maybe even elected official cars if they know who you are, to see if they can find information that you have open to the public that you shouldn't. So if a police officer may have police reports laying in his chair, and maybe that information has social security numbers in it, dates of birth, they will film that, and then they will enlarge it so they can see it really well, and they'll say, this is what your people, your employees are doing. They are showing this information for the public to see. And they can film that if it's a city vehicle. All right, so this is an example of how not to do this. I won't show the whole thing.
Oh, bro, you hit me with that, bro. That's the last time you're gonna use that hand. What's your name? So I could just go. I could just do that? Fuck out of my face, bro. Get the fuck out of my face, bro. Get out of my face. Don't you? Oh, can I just freely walk in?
No.
Why not? I just want to walk around the
No,
building.
you cannot walk around this building freely.
We're just doing a video.
Not no video of me.
Why not?
No, I'm not. I need get you down here at the front desk as soon as possible, ASAP.
You don't want to be filmed, sir? Why is that?
No, I do not want to be filmed. Please don't film me.
Why is that?
It's against my company policy.
You have to understand that you're in a public place, and you have to.
Actually, I'm in a state building.
This is a public building,
This
yes.
is a state of Tennessee building.
Correct. Who financed
so I'm
that?
asking you nicely, please do not record me.
Sir, I'm asking you nicely to please respect our rights. So that's part of your job, right? Disrespecting the public. Is it, sir? That's not a legal sound. I'm removing it. Hey.
Don't you touch nothing on this desk.
Oh, bro, you hit me with that, bro. That's the last time you're gonna use that hand. This guy's slamming stuff. We'll get your name, brother. Now we got the guys with the guns. The guys with the guns versus the guys with the cameras. Who's gonna win? May I have your name and batch number, please?
Sure. My last name is Barati. I'm the chief of the interdiction division here with the Tennessee Department of Correction.
You see, they're telling me I don't have the right to film in this building, which in fact I do. Could you please tell them I do?
Okay, so you want to film in the building. You've been doing so, as I understand, since
Yes, I need him to give up his ID for disorderly conduct.
Okay,
Or call the troopers. Call the right people. He needs to be ID'd right now. This is a First Amendment audit, and you guys just failed. It's going to be on YouTube, and it's going to be seen by thousands.
Amendment audit conducted by whom, sir?
By us, the people. Listen, this guy's breaking the law. Slow down, okay? Slow down. Don't interrupt me.
Witness anything?
Well, I have it on video. Maybe you want to see it? Maybe you want to see it?
You can make it out.
You know what? You don't want to hear that this guy's being disorderly. What part of disorderly you don't understand, dog? This guy's being disorderly. He nearly chopped my hand off with this. So I want this guy detained for disorderly conduct.
Okay,
How's that? Are you going to do that?
Okay, you want to show us your...
I want you to conduct an investigation. Yes. I need to know his
we'll
name.
address it.
What's his name? So I can address it.
I don't know his...
Okay, so he's detained. You're a police officer. He needs to be detained for disorderly conduct.
So here's the card.
No, listen, bro. This is not a
there's
card.
that.
There's a criminal situation right now. I'm requesting assistance. This guy was disorderly. This guy was disorderly. You see? So it's your job to detain whoever's breaking the law. Yes.
That wasn't disorderly.
Oh, that wasn't disorderly conduct.
Not in my opinion.
What's your name? So I could just go. I could just do that? I could just do that? No.
Did you damage it?
He could have gotten my hand, bro. What the hell are you talking about?
If you want to make a police report out...
Yes,
we'll
call
need
the police.
some identification from you.
No, we need it from him, not from me. Get the fuck out of my face, bro. Get the fuck out of my face, bro. Get out of my face. Get out of my face. That's freedom of speech. Get out of my face.
So
Get out of my face. I'm cool with you. You get out of my face. I'll speak with you, but this guy needs to get out of my face. This guy needs to get out of my face. Get out of my face. You're not a cop, bro. You're a tyrant. You want no part of criminal actions, right? But you want to stop my rights? Fuck you, dog. I was more than nice to you. This guy's being disorderly. This guy's being disorderly. You don't want his ID. You want my ID? Fuck you, dog. No, I'm not speaking with you at all. I'm speaking. Hey, don't. Who are you? Who are you? Who are you?
cameras down if you want to talk to me.
Who are you?
We get the report of
Who are you?
Can we help you?
Who are you? Don't you see this guy's fucking being disorderly? Are you a cop? Are you a cop?
I work in this building.
Are you a cop?
How can we help you?
Are you a police? Identify. Okay, so I don't need to talk to you. Go. No, I'm not speaking with you, bro. I'm done. This is done. This is done. Well, go away. Go away. I'm not speaking with you. Go away. Go away. Go away, bro. Do the walk of shame. You're not a cop. You're not a cop. You're not a cop. You're ignoring. This is dereliction of duty. Dereliction of duty.
What happened?
What's his name so I can walk away?
I already told you.
So get his name.
Never met this man.
So he's right there.
We're
Introduce
going to
yourself.
deal with it internally.
No. I need his name. I need his name so I can properly complain.
We are asking you
I'm gonna be here the whole day.
If you do not leave,
What are you gonna do?
You will be
Call the police right now because I want to make a report.
We're
I want
going
to.
to ask you to leave peacefully on your own accord.
Oh, and now I'm being what? What's up? Why is this guy threatening me right now?
To get his name, you guys could leave, correct?
Give me his name. Yes.
Can I get just your name so that if they want to file a complaint
Yes.
with the company, they can?
Steve.
Steve from Walden Security. No problem, Steve. Make sure you go check us out on the internet. You see, I won't forget your name. And I won't forget yours either. You're respectful. I like you, dog. What's your name?
Jonathan.
Jonathan. I appreciate you, bro.
Let me write this down for you.
You're a piece of shit, dog. You're a piece of shit. Oh, I didn't see it. Oh, I didn't see it. Although I showed you a fucking video, right? Right? You didn't see it. Thank you, bro. Thank you.
Paper there.
I appreciate
Get the request.
even though you're not honoring us to enter the building, you're being more than respectful and nice. Actually, the only one that's been nice. This guy's a complete tyrant. This guy wants to interrupt two men's conversation without identifying himself.
What you need to do, and who you're here to see how we can help.
Well, you never said, you see, you don't have the proper approach, bro.
You said if I got his name for you guys go ahead.
And I'm a man of my word.
Thank you, sir.
We appreciate
Have a
it.
good one. Steve, you're soon going to be Walmart security. You know, we don't need you working on the public building. Let's go nothing.
You're forgetting our legal counsel's card that you asked.
You're going to need one too. You're going to need legal counsel. You're going to need
Have
it.
a nice day.
You're going to need it. After you. After you. I'll leave after you. How's that? I will. But he needs to. You see, it's not how he wants it. I will leave right now, but you leave first, and I will walk away too.
Okay, sir.
You do it. After you.
Have a good day, guys.
You too. After you. Enjoy that walk of shame, tyrant. That's why we have 100 million views on the internet, you see? Because of tyrannical behavior with an iPhone. You guys are all tyrants. You're ignoring a security officer who's breaking the law by being disorderly, and then you want to put threats on the people who are entering and exercising their rights. That's very nice. Look at this guy. Look at this guy. Out of control. This guy's out of control.
The project manager is Bob.
Spell it B-O?
Yes.
That's the project manager.
Project manager, yes.
Project manager. I appreciate you, man. What's your name?
My name is King.
King. Have a good one, brother. Take care. Guys, that's why Mr. America does what he does. We are in Nashville, Tennessee, standing up for your rights. Let's get Steve removed from the state building. Go to Walden Security on Google. WALDEN Security in Nashville, Tennessee. I believe they're from here. So they're hired at the public building, public state building. Make sure you go over there and give them a 1-star rating. 1-star rating. Shout outs to Tammy. Shout outs to Fake Micro News. Shout outs to Chase from the Allen Report. Shout outs to Heather Ray TV. We'll see you on the next one.
All right.
That's why we have 100 million views on the internet, you see?
Oh. All right, so a couple things. I think if the person that was at the front desk had been trained, they could have just said, sure, you can film me here. There's a security area that you have to go through. If you have security, you can you can still make sure they follow all the rules to get through security. Anything that's public, though, anything that any public could be in is game for filming. And we really have to just think about that. I think if that person would have just been calm, or if this guy wouldn't have come in and turned his back, if he would have just asked him, what can I do to help you? And we do have to give our names, but we don't have to give our last name, or our first name. We don't have to give the whole thing. So a lot of times we just tell people, first name or last name, and if they ask what you do, you should give your title, because all of those things are public. But beyond that, you just try to be helpful. And if you're helpful, it's boring and they don't want to play it. This is one that was helpful. This is in Nolensville. I think this one is really good. It kind of shows you what you should do and how you should act. This lady's pretty famous. I think her name's Reba, if I'm right about that. She does this a lot. She goes around everywhere.
Hey, this is Reba, and I'm in Nolensville, Tennessee. This is the town hall. The police department is in the back of it. I just went and audited it. I'm going to put an article that News Channel 2 in Nashville put out about Nolensville Police Department. I'll put a link in the description, and maybe I'll pin it in the comments so y'all can see it. But they have been, the chief has been asking for and approving getting rid of the speeding tickets and other issues like that with city employees. of course, the higher up ones. I know one was a commissioner. So in the article that I'm going to put up, it does have a video on it that tells you everything if you prefer to watch that instead of reading it. So I just got my clothes on and ran over here just to check it out. And here's the video. There's an unbiased and fair treatment to all we encounter. That's not true. It is biased. Hi.
Hey, man, you doing all right?
Yeah, you?
Doing well. Can I
Well,
help you?
good. Do you work here?
I do.
You a police officer?
I am.
What is your name and badge number?
My name is Michael Turns. My badge number is 0005.
Cool. Is the chief in?
He's not.
Okay.
Is there anything I can help you with?
I'd love to set up an appointment with him.
Okay. Do you have a name and telephone number I can have him give you a call?
Yeah.
Okay.
Okay.
Let me grab a piece of paper. I'll be right back.
All right. Reba. Here, I'll write.
If you want to write it.
Sure.
Here, we'll write this by the way the sticky's on top.
Thank you.
Is there something you'd like to discuss or?
Yeah, it's regarding the article of News Channel 2.
Okay.
And I was curious because I was planning on getting a city job.
Okay.
But when I apply, I want to make sure it's for positions that if I get a ticket that I can get out of it.
Say what?
Like people that get out of tickets or
Oh, I
city
get what you're saying.
employees.
Okay. I'll have him give you a call.
All right. All right. Thank you.
Yes, ma'am.
That's how you make boring video. But as you're thinking about like City Hall and walking around City Hall, if you walk into a room or to an area in the city that's locked, make sure that you shut the door behind you. There was it might have even been, no, it was Bell Mead, I think. They were in the boardroom. They just came into the boardroom and they were filming. And then one of the doors that led to beyond the boardroom was unlocked and left open. And so they just went on in and they just kept walking. And they were in there with staff members that had really important, probably confidential things on their desk, but it was a non-public area. So really think about how you close doors. Don't let people come through secure areas unless you either have a meeting with them or they're supposed to be here, especially if they're filming. Let's not do that. So that's kind of First Amendment auditors. We don't really see them worried too much with elected officials yet, but I see this coming to you guys next. Any questions, comments, thoughts, practices? I know Bill's got some comments that if you need it, he's written out some basic statements that our staff can use whenever they're encountering a First Amendment auditor, just so they have something to say. Sometimes you don't know what to say, so you just either don't say anything or you act nervous. And if you have something to say, a lot of times it just makes it a little easier. Yep, that's the end. There are a lot more. Like I said, if you're interested, just go on to YouTube and put in First Amendment auditors. You can even put First Amendment auditors Tennessee or Franklin, and they're out there. We've been audited a couple times. They do think it's their job. Like this woman said, I saw a news article on Channel 2, so I put my clothes on and came on down, check it out. Okay. No, I don't think so. And it's a one-party recording state, but most of where you're going to be recorded is going to be in a public area. So, and what's interesting for most of what you do, you're recorded anyway. We have cameras all in that courtroom or all in the boardroom. So if they really want to record it, fine. We are also recording it. We're all recording it. But I would say out in public. So if they're watching you at some sort of an event and they record you, they might turn it in and say, I think I see an ethics violation here.
Sean, have you ever seen anybody record the recorders? So if they came in and saw us and we said, they're giving Ken a hard time in front of admin, if we just said, well, we're glad to talk to you, but we're going to record it too.
There is some video out there. I will say.
Would you recommend that or not? It'd be interesting because the guy was being a total jerk.
Yeah, he was.
But he's the one face you don't see.
Yeah. Yeah. I mean, I would just say this. It depends on how the situation's going. Like in that particular situation, it would have been great if the officer showed up and had body cam, because that would have been really helpful. But if it's going pretty calmly, if you pull out a phone and start recording them, it's going to make it worse. And that's the videos that I've seen.
Maybe not.
Yeah, well.
If you still keep your composure and do all the things you said, but you're also recording them, it just might be. So, I mean, we've done that occasionally where we've had a media member that we thought might be being a little difficult or maybe deceptive, so that we can say, well, this is actually how that interview went.
Right. These people are trying really hard to get you. And they know their line. They know not to touch you. They know what they can say, how to say it, when to say it. I mean, and there are actual Facebook groups and YouTube videos of how to do an audit and how to do it legally and not get yourself in trouble. I mean, yeah, I mean, cussing is a protected speech. That's true. But if he threatens, that's different. If he threatens. I mean, you created a public document. Yeah. You've created a public document.
You would do that knowing that is what you're doing.
Yeah. I agree with that.
Counterbalance,
If it starts to go odd, I would say the person being talked to shouldn't record, but have somebody else. So maybe come up with a plan just record this. I just want to make sure that we're doing it right, and if there is an issue, we have it recorded. Because you'll notice in the video the guy put on YouTube, he cuts and pastes a lot. So there's stuff happening that we don't know. Right. That's how, it makes for entertaining videos. He's not worried about the truth.
So, quick question on our current city hall that we have right now, and Eric, maybe you can speak to this, is do we have cameras in the lobby area in and around we'll call it the concierge desk, where
we have cameras,
secured, and is it mic'd up as well?
I don't think it's mic'd.
Yeah, I don't know. Some of them are and some of them aren't. I'm not sure.
Follow-up question on that is, as we move forward with city hall planning, and we're talking about these open public spaces, having security cameras that are mic'd, as well as, that executive greeting area, I don't know what you call that, the very first area.
Mm-hmm.
Just have to have kind of the foyer area before you go to the back.
Yeah, we have quite a few cameras through there. I know we've had things happen in the boardroom that we couldn't see, and so we used the cameras from the hallway to get the view inside the boardroom, and you can see pretty well from those cameras. They're really great cameras, but I don't think it picked up audio. But there are some that do. I don't really know which ones. Any other questions? Just be thinking, if someone walks up to you with a camera, have a game plan. What you're going to say, how you're going to say it, just be nice. Yes, short and sweet. Again, the good ones hardly ever end up on YouTube. The bad ones always do. Unless they want to use you as a good example compared to a bad example. We do see that a lot, where one city does it well, and then they're like, nah, watch this city, and who does it bad. Yeah, remain calm. Right. Now, this isn't geared toward media, but it doesn't really change, I don't think, the analysis of just knowing you're being videoed, stay calm, try to answer the questions, be nice. Again, we've seen elected and appointed officials do it wrong, and that's what everybody wants to see on their news at night, not the person who's just being really nice and answering questions. Any other questions? Okay, well, that is the end of the training. So if there's anything else,